બોલો. ઓફેન્સ મર્ડરનો છે. કોઈને છોડ્યા છે? આવતીકાલ આની ટ્રાયલ જુદી કરી હતી? ના ના, કો એક્યુઝની ચાલી ગઈ હતી કેસ એમ કહું છું. કો એક્યુઝનો ચાલી ગયો ને એને છોડી દીધો. જીએમ પાટીલ બીજી વાર આવ્યા જ નથી. ચલો ચોરી છે ને?
એમાં હું વિથ પ્રોસિક્યુશન એફિડેવિટ ફાઇલ કરવા માગું છું. LOBP અને એક મુદ્દો દરજ આવતીકાલે સાહેબ એફિડેવિટ.
શું મોડું?
યસ.
ક્યારે રાખ? 4-6. બાકી છે. હા, જીરા વાળું આવી ગયું. પછી બીજી થઈ. The base on which the predecessor had rejected was a count that charge sheet is yet to be filed and investigation is at nascent stage. Charge sheet is now being filed. I drew attention of people. આ પ્રોહિબિશન છે 39-24. હા એ બરાબર એ આવે એટલે જોવું. હા મિસ્ટર ભાઠા ભાઠાના સાહેબ વાળી લાવ છો. સંગઠિત અપરાધ વાળું છે એવું કે છે પીપી 111.
આમાં નહીં લાગ્યું પડે.
હા
300 115 બે 118 અને 352 અને 351 છે. એમાં 111 લાગુ નહીં પડે. 111 ની ડેફિનેશન ને સર જોઈએ તો એમાં સ્પેસિફિક એવું છે કે એવી સિન્ડિકેટ કે જે એવા ગુન્યા પ્રત્યક્ષ અથવા પરોક્ષ મહત્વના લાભ કે જેમાં નાણાકીય લાભ સમાવિષ્ટ હોય, અપહરણ, લૂંટ, વાહન ચોરી, ખંડણી, જમીન પચાવી પાડવાના ગુનામાં સોપારી આપવી, આર્થિક ગુના, સાયબર ગુના, વ્યક્તિની તસ્કરી અને ડ્રગ્સ.
પહેલામાં તમે બેલ આઉટ થઈ ગયા છો?
હા બધામાં.
ઓલપાડ વાળા?
જી સર બધે બિલ. એટલે આમાં હું આ 111 ની સેફ કોપી કરું.
હા GM પાટીલ 3666. ના આ 3666 ની પહેલા કહું. 3666 માં તો આ બીજી. હા એની વાત કરું. ચાલ પછી બોલો.
આ મૌલિક પરમાર છે એ પોતે જમીન દલાલીનું કામ કરે છે એવું વાત કરેલી. ત્યારબાદ એવું કહ્યું ફરિયાદીને કે જુનાગઢ સ્વામિનારાયણ મંદિરના જે કે સ્વામી આણંદ તાલુકાના રીંઝા ગામે સ્વામિનારાયણ સંપ્રદાયનું મંદિર બનાવવા માગે છે અને ગુરુકુળ બનાવવા માગે, એના માટે 700 વીઘા જમીન જોઈએ છે. અને આ જમીન જો એ ડાયરેક્ટ ખરીદે ખેડૂતો પાસેથી તો જમીનના ભાવો વધી જાય. એટલે આ કામના ફરિયાદીને એવું કહે છે કે તમે ખરીદી લો ને ત્યારબાદ તમારી પાસેથી અમે નફા સાથે ખરીદી લઈશું. આ ફરિયાદીને વાત કરતાં જે કે સ્વામીને મળવા ગયા ફરિયાદી જુનાગઢ મુકામે જાય અને ત્યાં એણે એવો ભરોસો આપ્યો કે તમે જો જમીન માલિક પાસેથી જમીન ખરીદી લો તો અમે તમારી પાસેથી નફા સાથે ખરીદી લઈશું અને તમે એક સુરેશ ભરવાડ નામના વ્યક્તિએ રીંઝા ગામના ખેડૂતો પાસેથી સોદા ચીઠ્ઠી અને સાટા ખતો બનાવેલા છે એટલે તમે આ સુરેશ ભરવાડ પાસેથી જમીનનું એમઓયુ બનાવી લ્યો એટલે અમે તમને 25% પેમેન્ટ રિલીઝ કરી દઈશું એવું સાહેબ જે કે સ્વામીએ આ કામના ફરિયાદીને જણાવ્યું છે. હવે ત્યારબાદ આ ફરિયાદી સુરેશ ભરવાડને મળે, સુરેશ ભરવાડની મુલાકાત થાય છે, બેની જોડે વાતચીત કરે અને પછી ફરિયાદીને એવું લાગ્યું કે ભાઈ આમાં કાંઈ યોગ્ય નથી એટલે એણે બધો પ્રોજેક્ટ બંધ રાખ્યો. ત્યારબાદ આ જે કે સ્વામી છે એ અને એના પીએ ભરત પટેલ એ ફરિયાદીને સુરત મુકામે મળે છે સાહેબ અને એને એવું સમજાવે છે કે ધર્મના કામમાં સહકાર આપો ને તમારા નામે ખરીદો એટલે અમને સસ્તી પડશે જમીન, આવું આવું સમજાવ્યું અને ફરિયાદી સમજ્યા જે કે સ્વામીની વાત અને સાહેબ એણે સુરેશ ભરવાડ સાથે મિટિંગ કરી અને એમઓયુ બનાવ્યા છે. એમઓયુ બનાવ્યું એટલે સુરેશ ભરવાડની સાથે સાહેબ એમઓયુ મુજબ એણે 1 કરોડ બાના પેટે આપ્યા અને બાકીના છે સાહેબ એને ચૂકવવાની કન્ડિશનો નક્કી થઈ. હવે આ બાના પેટે આપવાની રકમની વાત થઈ એટલે ફરિયાદીએ જે કે સ્વામીને કીધું કે 1 કરોડ રૂપિયા માગે છે, તમે મને પેમેન્ટ આપો તો હું આપું. એટલે જે કે સ્વામી એવું કહે છે ફરિયાદીને કે ભાઈ તમે 10 દિવસ માટે રોકાણ કરી દો તો 10 દિવસ પછી તમને 25% પેમેન્ટ આપી દઈશું. હવે સાહેબ આવી રીતે આ કામના ફરિયાદીએ સાહેબ સુરેશ ભરવાડને પેમેન્ટ આપ્યું છે. હવે આ કામે સાહેબ મુખ્ય આરોપી સુરેશ ભરવાડ છે સાહેબ. હાલના અરજદાર આરોપી છે સાહેબ એ જ્યારે વડોદરા મુકામ તારાપુર મુકામે સુરેશ ભરવાડ સાથે મિટિંગ થઈ ત્યારે આ હાજર હતા છે. હવે આ અરજદાર આરોપીએ સાહેબ કોઈ એમઓયુ સાઇન કર્યું નથી. એક એમઓયુ સુરેશ ભરવાડ આરે થયું એમાં સાહેબ સાક્ષી તરીકે અરજદાર આરોપી છે. આ અરજદાર આરોપીએ સાહેબ આ જે 1 કરોડ રૂપિયા છે એમાંથી કોઈ રકમ મેળવી નથી કે એના ખાતામાં પણ નથી આવી. આ સુરેશ ભરવાડ અને ફરિયાદી સાથે સાહેબ ઘણા એમઓયુ છે અલગ અલગ, પણ ફક્ત એક એમઓયુમાં આ સાક્ષી તરીકે હાલના અરજદાર આરોપી છે. અન્ય આરોપીઓ જે સાહેબ એણે નાણાકીય લાભ મેળવેલા આમાં અને કોઈ 2 લાખ કોઈ 3 લાખ એવા સુરેશ ભરવાડ પાસે 1 કરોડ રૂપિયા આવ્યા એમાંથી બધાએ ભાગ પાડ્યો છે. એ લોકોને સાહેબ નામદાર કોર્ટે સાહેબ જામીન ઉપર મુક્ત કર્યા છે, એના વિરુદ્ધ ચાર્જશીટ ફાઇલ થઈ ગયા છે અને એ જામીન મુક્ત થયા છે. એને ડિપોઝિટ કરાવી રકમ એને જે લાભ મળ્યો હતો એ પ્રમાણે સાહેબ આ સુરેશ ભરવાડ મુખ્ય આરોપી એને સાહેબ નામદાર ગુજરાત હાઈકોર્ટમાં સ્ટે આપેલો, એણે ક્વેશ્ચન પિટિશન ફાઇલ કરી છે સાહેબ, એમાં સ્ટે છે સાહેબ. અને સાહેબ હાલના અરજદાર આરોપી અને સુરેશ ભરવાડ એ બે ભેગા મળીને ફરિયાદીને કોઈ વિશ્વાસ કે ભરોસો આપ્યો હોય એવું નથી સાહેબ. આ ટોટલ આખા કાર્યની અંદર સાહેબ જે કે સ્વામી એણે ટોટલ ફરિયાદીને ભરોસો આપ્યો. સુરેશ ભરવાડ સાથે મુલાકાત કરવાનું જે કે સ્વામી કહે છે ફરિયાદીને. ધર્મના કામમાં સહકાર આપવો એવી લોભામણી સ્કીમો સાહેબ જે કે સ્વામી આપે છે. આ જે કે સ્વામી
યસ પીપી
અને સાહેબ જે કે સ્વામી પણ જામીન પર મુક્ત છે.
those who are bailed out. ને આજે બાકી ચાલો હા હા શું કરવાનું તમે કોના વતી એની તમે એક્ઝામ્શન આપી છે 2 નંબર ક્યાં છે વકીલ તમારા સારું પૂછી લો એમને ચાલો ચાલુ થયું છે આમાં કે ચાર ફ્રેમ નથી થયું ચાલો પછી એકવાર 299ની અરજી આપી તો 21ની છે ને એમાં ફરિયાદીને તપાસીએ કશું આવતું ન હોય પછી 17/6 હા ચાલો બીજા પ્લીઝ બહાર જાઓ ને આ કેસ સિવાય આ કેસમાં જ હોય એ જ બેસ બીજા ના બેસ
લાવ્યો ભરત સ્વામી કયું છે હા એમ શું કર્યું એને બોલાવી ગયો
5-8
ન મળતા હોય તો સોગન નામ કરવું બજારવાળા બોલાવી ગયો મારે કોઈને બજ્યું છે બજાર કરવાના બોલાવી ગયો હા અત્યારે બોલાવી પેલા ફરિયાદીનામાં ફોન કરો 894
ચાલો પછી નેક્સ્ટ 5-8 પાંચ આઠ પાંચ આઠ તમે રોક્યા વકીલ? હું અહીંથી આપું કે તમે રોકી લેશો? તમે રોકી લેશો? ઓકે ચાલો પછી
હા એને પેલો આવીને સોગંદનામું કરાવે ન મેળવે બજવણી નથી થતી નથી મળતી તો એની પાસે સોગંદનામું કરાવીને રેકર્ડ કરવું.
કેટલા વતી મૂક્યું તમે? એનો તમે એક્ઝામ્પશન આપ્યું? તો 3 નંબર જ આરીફ
આ
છે.
3 નંબર છે.
3 જણા વતી મૂક્યું, 2 4 અને 5. 3 નંબર બજુ નથી. 1 નંબર હવે વકીલ રોકશે. ચાલો 6 8 સાંજે ઓર્ડર આપી ગયું, ડી લિસ્ટ આપી ગયું.
બાકી છે સાહેબ મંગાવી લઈ.
6 7 આ ચાર્જ માટે છે.
હા
9 7 7 8 ચાલો પહેલેથી લઈ લો. થઈ ગયું અમને?
એ બોલાવ્યા છે બોલાવ્યા બજવણી
ચાલો
કરવાની
ફરિયાદીનું પેલામાં
ફોન કરે
આમનામાં તારીખ કઈ?
હા એ ઓનલાઈન
ચાલો આ 2 નંબરમાં એફએસ થઈ જાય પછી દલીલો માટે ક્યારે રાખવું? દેસાઈ
દલીલ માટે ક્યારે લેખિત જવાબ રજૂ કરવા માટે
ક્યારે રાખવું? નેક્સ્ટ વીક?
હા નેક્સ્ટ
8 તારીખ. ચાલો પછી 4 નંબર 36 66 જીએમ પાટીલ.
હા અત્યારે બીજું છે.
આ સક્સેસિવ છે ને? લાવ
આ છે બીજી મેટરો અગાઉ ડિસ્પોઝ થયેલી ને આ નાસ્તો કરતો હતો. 2008ની મેટર છે. પકડાણું હમણાં 8/1/16. હમણાં બીજી કોઈ કરી
બીજી
નથી.
વાર આવ્યો કારણ કે આવતો જ નથી. કઈ નહીં, કાલે ચાલ ટાઈમ કાલે પછી લખજો બી ગેરહાજર. ચલો 3 ઓર્ડર માટે આવતીકાલ, 5 ઓર્ડર માટે 6/2/6, 7/4/6, પછી 8 39/15 લાવ. ચોરી છે ને?
હા,
ચાલ 8 ઓર્ડર, 9 ઓર્ડર, 10 ઓર્ડર, 11 ઓર્ડર, 12 નંબર,
હા, હા.
આમાં પીટીની એ દલીલ થઈ ગઈ છે અને નંબર 1 વતી લેખિત આવી ગયેલી છે. તમારે તમે 2 અને 3 વતી છો, 4 તો ગુજરી ગયા. એ ક્યારે કરશો? બોલો. કોર્ટ તો આજે કન્વિનિયન્ટ છે. બોલો.
લંબાઈ છે મેટર એટલે જલ્દી મેટર લંબાઈ છે આર્ગ્યુમેન્ટ એટલે 1 વર્ષ.
એવી જ તારીખ લો તમે પૂરી કરો. ચલો. હાઈકોર્ટ તમે આટલો ટાઈમ રહ્યા, વોશિંગ તમારી તમે નોટ પોતે વિડ્રો કરી, હવે અહીંયા આગળ ફાઇનલ આર્ગ્યુમેન્ટ આવી, પીપીની દલીલ પતી ગઈ, આરોપી નંબર 1 એવું કહે છે કે મેં તો લેખિત આપી દીધી છે. મહિનો નહીં, જે તમે આ મહિનાની કોઈ પણ તારીખ માંગો આઈલ પરમિટ. ચાલો આર્ગ્યુ ઇટ આઉટ. ચાલો 30 તારીખ બસ આપો, અરજી આપો. ચાલો 30મી ગમે તેમ કરીને પૂરી કરતો, અને એ પહેલાં ના હોય તો ફરી કરીને લઈ આવો ઓર્ડર. સિરિયલ નંબર હા 7. ચલો હવે 12 નંબર 30/6, 13 નંબર 17/6, 14 નંબર 15/6. ચાલો 15 નંબર શુભમ નામદેવ પાટીલ. 15/6. ચલો નેક્સ્ટ 16 નંબર 5/8, 17 નંબર આમાં
એમાં
આવે છે.
ઝૂમ ડાઉનલોડ કરીને જોઈન્ટ થાય છે.
18 નંબર 5/8, 19 5/8, 20 5/8, 21 6/8, 22 5/8, 23 6/7, 24 9/7, 25 7/8, 26 ઓર્ડર, 27 4/6, 28 4/6. ચાલો યસ, એની મેન્શનિંગ ઇન ક્રિમિનલ. પછી હું સિવિલની આ ટાઈમ બાઉન્ડ મેટર ચાલુ કરું. હા હા ઓર્ડરમાં. ચાલો
વોટ્સઅપમાં જોઈન્ટ થઈ જાય.
લાવ આ દરખાસ્ત આપી.
સર વોટ્સઅપમાં જોઈન્ટ થઈ જાય ફરિયાદ.
હે હા એક You have to begin or the
I have to begin.
yes. Proceed.
Ji, we have, for your honor's convenience, we have given a compilation.
Today.
जिसमें सारे जी पहले दिया हुआ है या दे रहे हैं अभी काउंसिल कोर्ट में है.
ઇનફેક્ટ આમ અત્યારે જ આપી રહી છું ત્યાં. પહેલાં પણ જે પહેલાંના જે રિસ્ટોર કર્યા છે એમાં પણ આ કન્વિનન્સ કમ્પાઇલેશન છે જ. ખાલી 3 ડોક્યુમેન્ટ્સ એડ કર્યા છે જે પેજ નંબર 341 ઓનવર્ડ્સ છે. બાકી સેમ કન્વિનન્સ કમ્પાઇલેશન છે જે પહેલાં ટેન્ડર કરેલું છે.
That will just be a little convenient for your honor because the issues are very limited. As your honor knows that this has come back on remand from the High Court.
Yes.
Yes. So I would just go through a few dates from the compilation itself which are relevant. These proceedings are under the National Highways Act. And the current proceedings before your honor are Section 36 arbitration proceedings. Execution, so to say. Our basic case of NHAI is that these executions are invalid and honest because they are based upon an award which could not have been passed, is without jurisdiction, has been passed by the arbitrator under the National Highways Act outside the time, without consent, without notice, and in addition, it has been passed after the arbitrator's mandate had terminated under Section 32 of Arbitration Act. This is our basic case. And there are judgments of the Supreme Court as well as the Gujarat High Court as well as other courts which completely confirm the position. So, if I may straight away start with the few relevant dates.
Yes.
So, this is 17/3/2018 at page 2 of the convenience compilation.
Page.
Page 2.
Yes.
This is the compensation was determined. Your Honor, may only mark it, इसमें कोई dispute नहीं है. None of the dates are disputed. So this is compensation which was granted by Kala, the competent authority under 3G of the National Highways Act.
Yes.
ये 3G1 में proceedings होती है under the National Highways Act by Kala, and उसके बाद arbitrator decides in case of any dispute. Then the next date which is relevant is at page 107, which is 6th February 2022. This is the final award of the arbitrator. 6/6/22. Your Honor, may only note it is not in dispute. None of this is in dispute.
Yes.
This award is received by the landowners on 17/6/22. ये पेज 373 में देखेंगे आप. 373. This is received on 17/6/22. I'll just show that part. (373)
373 marks the intimation to the.
वो उनकी अपनी लेटर है. There is their own letter of the landowners जिसमें उन्होंने रिकॉर्ड किया हुआ है that they received it on this date.
280.
373.
280.
280.
Landowners have informed to 80.
Yes. They have informed to the 80, correct. If your honor will see the letter itself, respected sir, the order received from the Honorable Arbitrator, office order dated so and so, dated 6/6/22, यही award की date है, received on 17/6/22. Has your honor got that? This is the landowner's own letter to the 80. Your honor is absolutely right. Now, I will just divert for 1 minute here to the Arbitration Act itself. Section 32.
Yes.
On the award being passed by the arbitrator and on receipt by it, there are two features which come. So, Section 32 एक मिनट जनाब देख लेंगे. So, Section 32 says the following. The arbitral proceedings, has your honor got the act?
Yes.
Yes. The arbitral proceedings shall be terminated by the final arbitral award or by an order of the arbitral tribunal under subsection 2. And then subsection 3, subject to section 33 and subsection 4 of section 34, the mandate of the arbitral tribunal shall terminate with the termination of the arbitral proceedings. तो हमारा ये contention है basically कि 17/6/22 पे, when the award was passed by the arbitrator, the mandate of the arbitrator terminated, he became functus officio after that. It is like the honorable judge passing an order and after that becomes functus officio in that respect. Similarly, section 32 so prescribes. Then, if your honor will kindly just see further, एक मिनट section 33 भी देख लेंगे. इनका claim है कि हमने section 33 फाइल की थी, which is at page 373 जो चिट्ठी आपको दिखाई थी, and because of that a subsequent award was passed. Now kindly see section 33 for a moment.
So according to other side, it is the additional award that is passed by the ATM.
Correct. According to us, the additional award is absolutely functions, is non-est, illegal, without jurisdiction, and after the mandate of the arbitrator has terminated, one. Secondly, it is our contention कि जो section 33 की alleged proceedings है वो वैसे भी void है, because it is outside. Supreme Court has held it must be within 30 days as per the statute and with notice to the other side. दोनों criteria met नहीं है. That is our basic case. And the third argument, if any, by the other side has been कि we should have gone in section 34. और अब objections execution में नहीं डाल सकते only. Supreme Court has held in 3 judgments followed by other courts that it can be so done if the award is non-est and a nullity, and after the mandate is terminated, the objections can be taken in execution both under section 47 as well as under the Arbitration Act in particular. ये basic case है. And if I may just show section 33 जो criteria है,
Yes.
correction in interpretation of award within 30 days. Within 30 days from the receipt of the award. तो अवार्ड जनाब इनको मिला है 17/6/22 को पास हुआ है, 17/7 को 30 दिन खत्म हो गए. They have filed their letter or whatever they call that section 33 on 16/9/22. Well outside the time. उस डेट पे मैं अभी 1 मिनट में आ रही हूँ. And again, it is without notice to the other side that anything happened. Without notice to us. So kindly turn to page 373 now.
Yes.
I'll go back to the act. Page 373 is this letter of theirs, जो मैंने आपको अभी दिखाई थी. Now this is the order received from the Honorable Arbitrator, office number so and so, dated 6/6/22, received on 17/6/22, due to discrepancy, omissions, and urgency in order. After that, we were compelled to request a meeting with the Honorable Arbitrator, physical hearing conducted on so and so, in which we were asked to submit list of dates. Now this is their letter. जरा इसके ऊपर देख लीजिए, लेटर के ऊपर जो डेट है 16/9/22. इन्होंने फाइल नहीं की. फाइनली वी हैड टू गेट अ कॉपी ऑफ द लेटर. हमने फिर वी हैड प्लेस्ड इट बिफोर द हाई कोर्ट. They had deliberately not filed it. Anyway, now it is on record before the Honorable High Court as well as before yourself. 16/9/22 को इन्होंने फाइल किया है ये application, which is well after, more than 2 months after.
Counsel, sorry to interrupt on account. I got the
Yes.
point on account. Let me just now gather
Yes.
what actually you have sought in this.
We have sought. Yes.
Ah,
So we have sought for 2 things. We have
Yeah.
sought for the execution petition, execution proceedings to be quashed.
ah.
Basically, that is our case today.
In that regard, you have filed the objections.
Yes.
Now, what had happened when these objections had been decided and matter went to High Court?
I'll just come. 1 minute, ये दो dates और देके I'll come to those dates. वही dates है जो आपको दिखानी है. You're right. So then this was a letter of 16/9/22 जो they claim करते हैं कि section 33 की application थी, जो हमारे हिसाब से वो भी नहीं है, but that's another matter, which is filed after 2 months, so according to law, illegal. Thereafter, on 21/10/22 at page 122 of the compilation, ये second award pass हुआ है, what is called the Margdarshan Award. 21/10/22, page 122.
Yes.
Kindly just note it. Your lordship doesn't have to see anything further. ये मार्गदर्शन अवार्ड है, टॉप में बस देख लेंगे एक बार. 122 पे, passed by the arbitrator, Land Acquisition Branch, Collector's Office, Surat. Then after this, at page 143, जो competent authority under the National Highways Act, इस basis के ऊपर, second award के ऊपर, 29/12/22 को passes an award and gives compensation. Further compensation. पहली compensation हम लोग दे चुके हैं. The earlier compensation as per the earlier award of 6/6/22 has been paid. So after this Kala passes an award, ये लोग application execution की डालते हैं, which comes before your honor. Thereafter, at page 189,
These subsequent award, that is 29 December 2022, is in compliance to the
Margdarshan award. जी,
21st October 22.
absolutely, absolutely.
Okay.
We will give your honor a list of dates also. आप देख लेंगे उसमें, but this is absolutely correct. Then the learned additional district judge at page 189 passes a distress warrant. Issues. इसके खिलाफ हम लोग हाई कोर्ट जाते हैं, and High Court grants liberty to NHAI to approach the executing court with objections. Page 198 पे. So all that has become, in a sense, history. Kindly see page 199, High Court ka order. At page 199. Considering the submissions made, permission as sought for is granted. It is open for...
Just a minute.
जी. I'm sorry. I'm sorry, बहुत बैकग्राउंड है your honor, so थोड़ा बहुत तो देना पड़ेगा. I'm giving minimal.
No. I'll need better assistance of both the councils.
Of course.
Being novice, let me just take a time.
No, your honor. This court has wide experience in the commercial side, I understand. Page 199, I was showing you, honor.
I think it begins from 198.
Yes. वो पहला कुछ ज़्यादा इतना था नहीं, but I will show the whole. छोटा सा है. So from page 198.
198, you withdraw the petition at High Court.
Yes.
With liberty to prefer the objections.
Yes.
This court.
Correct. तो हमने objections इस कोर्ट में डाली. The High Court permitted us to proceed with that. So that chapter is as such over. It is before your honor now. Then at page 205.
Yes.
The executing court, the 14th additional district judge, again rejects the objections made by me. And a totally preposterous ground actually. अगर आप पेज 208 पे देखेंगे, the learned additional district judge holds objections raised, approximately line 8. Objections raised by NHA have already been decided by an order dated 15/3/25 and no new grounds for objections have been raised, and therefore the same objections cannot be decided once again. High Court ने liberty दी है, specific terms, and the learned additional judge wrongly holds that all this has been decided, इसलिए nothing survives. Then, after that, we file a civil division once again.
Yes.
And we are coming now to the somewhat of the closing of the dates which are relevant. Then the High Court on 23rd February 26, my Lord Justice J.C. Doshi, at page 368, कॉम्पिलेशन के पेज 368 पे आ जाएंगे.
Yes.
I assailed this order whereby district judge had rejected my objections, and by order dated 23 to 26, I can read out the whole order, but if I may, para 8 पे अगर आ जाएंगे page 371.
Yes.
After substantial arguments were advanced, learned senior counsel as well as learned advocate for both sides upon instructions jointly requested this court to remand the matter to the learned executing court for a fresh adjudication, with a direction to consider the objections, mere objections, afresh in the light of the earlier order passed by the coordinate bench of this court, and to examine the true scope and import of Section 33 of the Arbitration Act. All this was argued before the High Court, but the High Court felt it was appropriate that this Honorable Court consider the issues. And then, having regard to the rival submissions and in order to subserve the ends of justice, this court is of the considered opinion that the impugned orders deserve to be set aside and the matters remitted for de novo consideration. Accordingly, the impugned orders, वही जो 14th additional district judge का rejection था, are set aside, are hereby quashed and set aside. The objections filed by the judgment debtor are restored to their original file before the learned principal district judge Surat for fresh adjudication on merits. The learned executing court shall scrupulously adhere to the directions issued by the coordinate bench in the earlier special civil applications and shall treat the objections as fresh objections, deciding the same in accordance with law and in the proper perspective of Section 33. So, Your Honor has to see Section 33 fully, which is the main case here. All contentions of both sides are expressly kept open. The decree holder shall be at liberty to file reply to objections or reply if so advised. हमने further एक additional reply file कर दिया था, if so advised. The learned executing court shall first adjudicate the objections filed by judgment debtor on their own merits before proceeding further with the execution proceedings. It is further directed that the event any order adverse to the judgment debtor is passed upon such reconsideration, the operation and implementation of such order shall remain in abeyance for a period of 1 month from the date of its pronouncement, so as to enable the aggrieved party to avail appropriate legal remedies for expeditious disposal. Then the schedule is set out. Upon completion of pleadings, the learned principal district judge Surat is requested to decide the objections as expeditiously as possible and preferably within a period of 8 weeks in accordance with law. So this is the last operative order whereby your lordship has been asked to consider the matter afresh, particularly keeping in mind Section 33 of the Arbitration Act and considering the same in its proper perspective. That is why I told Your Honor in the first instance कि जो main issue मुद्दे दो हैं.
Now,
One.
only minute
जी.
before you navigate and carry the court to the real transit of the Section 33.
Yes.
Have you challenged this additional award or the so-called additional award as per the other side on account on a preliminary point of limitation under 33 or the merit?
We've challenged on both counts, or not on merits. We've challenged on preliminary counts. We are saying it is nullity. It is without jurisdiction. ये पास ही नहीं कर सकते थे.
Okay. So your
And
count,
that-
your count is that upon efflux of 30 days,
Yes.
it cannot entertain Section 33 application.
Correct.
Therefore, that application to the extent that the order that is passed below that application to the extent is void and non-est.
Correct. And the second point, if I mean, absolutely 100%, this is one of our cases. The second point is Section 32 also, which says once the arbitrators passed an award, he becomes functions officio. उसका mandate terminate हो जाता है. Matter is over. Except,
if I am not mistaken, the another aspect at the commencement of your submission to the effect has been there that you had not been called upon. Notice
that's right.
So that aspect has also been there. Principal
Correct. So
justice
to correct. So your honor is right. My main contention is A, section 32 में जब arbitrator award pass कर देता है जो उसने 6/6/2022 को फाइल पास कर दिया, he becomes functions officio accepting in under section 33. Now section 33 जब आ जाता है तो section 33 की दो requirements है which are mandatory and Supreme Court has held it in clear terms. कि it must be within 30 days of the receipt of the award and secondly it must be with notice to the other side. अब पेज 373 पे जो हमने आपको एप्लीकेशन दिखाई है उनकी, उसमें कोई भी ना नोटिस है ना कुछ है, वो अपने आप आर्बिट्रेटर के पास जाते हैं, कोई चिट्ठी भेजते हैं, वो चिट्ठी कोई उनकी कोई मीटिंग भी अलेज्ड होती है, जो भी होती है, arbitrator passes an award in that fashion. So the mandate of law is clear. If an award is a nullity, if an award is without jurisdiction, if an award is outside the mandate as prescribed under the Arbitration Act, then the award has to be set aside, and obviously all the executing proceedings have to go. Yahi,
Two counts have been there. 33
Yes.
one, that it is the adjudication had been upon the application that has been time barred, and audio
Yes.
part. Two aspects.
Absolutely, 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 absolutely. So, abhi, if I may, with your permission, I may just show the judgments which deal with this. We have filed the volumes also. There are few judgments we'll refer to right now.
Yes.
So the judgments we are referring to are, the first judgment is Electro Steel, which is a Supreme Court judgment.
Yes.
This is at volume 1. In fact, it's the first judgment in volume 1 of the judgments.
Yes. Yes.
Yes. If Your Honor will straight away come to, this is in the context of Arbitration Act
Yes.
and also deals with section 47 of CPC as a guidance. Objection section 47 may be dalte, as Your Honor normally would be hearing, I'm sure. So at page 18,
Yes.
section 47, paragraph 48.1.
Yes.
Section 47 of the Code of CPC deals with questions to be determined by the court executing decree. As per subsection 1, all questions arising between the parties to the suit in which the decree was passed and relating to the execution, discharge, or satisfaction of the decree shall be determined by the court executing the decree and not by a separate suit. Execution of decrees and orders is provided for in Order 21 of the CPC. The law is well settled that at the stage of execution, an objection as to executability of the decree can be raised, but such objection is limited to the ground of jurisdictional infirmity or voidness. The law laid down by the court.
I'm sorry, once again. These
Ji.
probably you have been making it down for the reason that you have not preferred separate section 34.
Correct. I haven't, and I maintain the fact, and that is the law on the subject, that I don't need to raise, and so it has been held. Next paragraph mein ye hold kiya court ne. Your Lordship is right. The law laid down by this court on Vasudev Modi versus Rajabhai Abdul Rahman is that only a decree which is a nullity can be the subject matter of objection under section 47 of CPC and not the one which is erroneous either in law or in facts. The aforesaid proposition of law continues to hold the field. Objection to execution of an award under section 47 of the Code of CPC is not dependent or contingent upon filing a petition under section 34. In as many words it is held. And this is an Arbitration Act proceeding, which I have just read out here. The High Court was not justified in taking the view that since the appellant did not file a petition under section 34 of the 1996 Act, therefore it was precluded from filing an application before the executing court to declare the award as void and hence non-executable. And in these circumstances, the award is set aside. And this is the background of this case. So in terms, वही जो आपने कहा कि सेक्शन 30, इनकी आर्ग्यूमेंट ही है कि आप सेक्शन 34 में जाते. This court has no jurisdiction. Executing court has to just execute, do nothing. Supreme Court says no. Executing court, if it is a jurisdictional infirmity, the award is void, has to take into account and decide. It is not dependent by section 34 डालूं नहीं डालूं, that's another chapter. Not relevant. Because of jurisdictional infirmity. And then if Your Honor...
Only on account to look into.
Yes.
Presently, this court is not apprised about
Yes.
what AT has passed the order under 33. This court is
Yes.
not sure to the effect.
Yes.
Now, if it is in increase in the compensation to the effect,
Yes.
that has been there on account to by altering the factors on account to look into or something, whether that will fall within the ambit of these three diametrics. Execution.
No, your honor is right. The question is, may I just respond to your honor? Section 33 का जो award है, जो pass हुआ है order, that is a margdarshan award. And margdarshan award is enhance the compensation. Whatever the factors are, the reason I am not going into the merits is because I don't need to. But it has enhanced compensation, your honor will take it. We are saying that that exercise is invalid, illegal. It can't be done. उन्होंने enhance किया तभी तो the whole fight is on that only. They are absolutely unjustified. They have taken the money from the original award 6622. उसके बाद ये application भी application 33 की है भी या नहीं है, itself is doubtful. जो भी है, अगर आप एक मिनट मान के भी चलिए कि section 33 is not my case, it is their case. तो section 33 आप डाल ही नहीं सकते थे 30 दिन के बगैर, ना नोटिस हुआ है, कोई अवार्ड पास कर देते हैं, फिर आप उसको एक्सिक्यूटिंग कोर्ट पे फिर आ जाते हैं, कहीं मुझे पैसा मिल गया, मुझे और चाहिए. So that is not maintainable under the law as it stands. So then, if I may, the other judgment is at page, it starts from, this is Gujarat High Court in Integro. We had shown it to the Honorable High Court also. In fact, he specifically marked it to you, this Honorable Court, feeling it had the appropriate wisdom and the expertise to deal with this. So this judgment is at page 22. Starting from 22.
Yes.
And then the questions that are framed in this is at page, I'm sorry, the page is 3. This is volume 1. Volume 1 only, page, the relevant paragraph starts from page 3. Page 3.
Page.
Page 3.
Number 3.
Ji, page 3, paragraph 18. I'm sorry, Your Honor, I have made an error. I went back to the other judgment. मेरे से गलती हो गई. Please take page 34.
Yes.
This is Integro, judgment of the Honorable High Court of Gujarat.
Chief Justice judgment.
Ji.
Ah.
Paragraph 9.
Yes.
The second issue is with regard to setting aside the arbitral award in proceedings under section 36 of the Act. आपके सामने section 36 Act की proceedings चल रही हैं. Execution, arbitration में section 36 में होता है. The object of the court is to safeguard their rights and uphold the principles of natural justice irrespective of procedural hurdles. Even if an award is not set aside under the procedure established under section 34 of the Act, the courts can nullify the award which was non-est in law. While section 47 of the CPC is not directly applicable, guidance can be sought from the jurisprudence of the Honorable Apex Court vis-a-vis decrees passed while lacking inherent jurisdiction. Such decrees do not exist in the eyes of law, and similarly, awards passed while lacking inherent jurisdiction can be said to have never existed. They don't exist. It is settled law that a decree passed by a court without jurisdiction on the subject matter or on the grounds on which the decree made which goes to the root of its jurisdiction or lacks inherent jurisdiction is quorum non judice. Section 32 में पास कर दिया, खत्म हो गया award, quorum non judice. A decree passed by such a court is a nullity and is non-est. Its invalidity can be set up whenever it is sought to be enforced or is acted upon as a foundation for a right, even at the stage of execution or in collateral proceedings. Not only execution, आप उसको collateral proceedings में भी challenge कर सकते हो. This is without jurisdiction. The defect of the jurisdiction strikes at the very authority of the court to pass decree, which cannot be cured by consent or waiver of the party. मतलब वो कहेंगे भी तो भी permissible नहीं है. This is the law. In the instant case, next page, para 12.
Yes.
In the instance case, para 12, it is palpably clear that an arbitral award passed by unilaterally, इसमें unilateral appointment थी, which was set aside. Unilaterally appointed arbitrator will not survive the section 34 challenge Section 36 provides no scope of adverse inference with an arbitral award except executing it as a decree of the court. However, there is no denying the fact that the act is a complete code in itself. Therefore, the question would be, when the award sought to be executed is a nullity for lack of inherent jurisdiction can be set aside in an executing proceeding. Analogy can be also drawn from the Code of CPC. Section 47 of the CPC governs the challenge to a court decree at an execution stage. Such similar provision is not provided in the Arbitration Act. The award so enforced under Section 36 of the Act is a nullity for lack of inherent jurisdiction. Therefore, it goes to the root of the competence of the court to try the case and an award. Therefore, the executing court can therefore entertain an objection that the decree is a nullity and can refuse to execute the decree. The executing court under Section 36 cannot shut its eyes to the grave irregularity that will occur if it does not interfere. And therefore, anyway, this award was set aside, though on a question of unilateral appointment. But the law is clear. जो चीज गलत है वो गलत है. You cannot say कि executing court will blindly say it is wrong, not wrong or right, but I will proceed. That is the basic question in hand. Then, if Your Honor will see at page 63, the Delhi High Court.
63 of volume 3.
I'm sorry. Thank you, Surat. Volume 3, Janab. To assist this court after the submissions are over, I will give a note with all these references.
Yes, 63.
This is Delhi High Court judgment, which starts from page 59, but relevant if I may take it to 63.
Judgment of Gowra Petrochem.
Ji. My Lord Justice Hari Shankar was the Delhi High Court judge.
Yes.
Para 18, the court is unable to persuade, at page 63, para 18. This court is unable to persuade itself to accept the aforesaid contention of the learned counsel for the decree holder. It is a settled principle of law that enforcement cannot be permitted in respect of an instrument, decree, determination, or adjudicatory outcome, which is ex facie void, ab initio, or constitutes a nullity in the eyes of law. A determination suffering from an inherent lack of jurisdiction strikes at the very root of the adjudicatory process and consequently cannot be sanctified merely on account of lapse of time or failure of a party to constitute an independent challenge thereto. Therefore, Section 34, same things again. Furthermore, as already noticed here and above, the division bench of this court in Mahavir Prasad Gupta, particularly in paragraph so-and-so, has unequivocally expounded the legal position that while exercising jurisdiction in enforcement proceedings under Section 36 of the ANC Act, Arbitration Act, read with Section Order 21 CPC, the executing court is not rendered powerless or functions officio. On the contrary, the court is fully competent to decline enforcement where the award sought to be executed is found to be a nullity on account of an inherent jurisdictional defect, including where the arbitral proceedings arise from a unilateral appointment of the arbitrator. The division bench has categorically held that such an award is non-est and incapable of enforcement. The aforesaid position also stands authoritatively settled by the Supreme Court in Electrosteel. वही जो पहली judgment, the first judgment I had referred to, while dealing with a substantially similar objection concerning the executability of an arbitral award in the absence of proceedings under Section 34, Honorable Supreme Court, while examining the scope and interplay of Section 36 of the Arbitration Act and Section 47, categorically held that although an arbitral award becomes enforceable as a decree upon expiry of the limitation period prescribed under Section 34 of the Act, the executing court nevertheless retains jurisdiction to examine objections pertaining to executability where the award suffers some jurisdictional infirmity or voidness. The Honorable Supreme Court in the said judgment observed that Section 36 of the ANC Act merely assimilates an arbitral award to a decree for the purposes of enforcement and that the execution of the award is consequently governed by the principles contained in the CPC. further held that Section 47 of the Act CPC empowers the executing court to determine all questions relating to execution, discharge, or satisfaction of the decree, and that a decree which is a nullity owing to inherent lack of jurisdiction can validly be questioned at the stage of execution. The Honorable Supreme Court further clarified that the maintainability of such objections under Section 47 is neither dependent upon nor contingent upon the filing of proceedings under Section 34 of the Arbitration Act. And so the court goes on to set aside the proceedings in paragraph 24, dismisses the execution application at page 67. Para 24 at the bottom. In view of the aforesaid discussion and having regard to the settled legal position in this regard, the court finds itself unable to lend its imprimatur to the enforcement of the impugned arbitral award, the present execution proceedings being founded upon an award which is rendered void and unenforceable in law, cannot be permitted to continue. Consequently, the present execution petition is dismissed as being incapable of enforcement. And then, if I may take your honor to the fact that Section 33 is limited in its application. Aside from the merits, which I am not going to, Section 33 के दो criteria, they have to be met. This is the law which has been held and confirmed in other judgments. So, for a starting, we will take Geojit, which is at volume 1.
Yes.
Geojit is relevant. Finding is at paragraph 7 at page 71.
Yes.
Page 71, the court, para 15. It deals specifically with Section 33. Section 33, para 15, page 71.
Yes.
Section 33 deals with requests made to the arbitral tribunal for correction and or interpretation of award and also for rendering an additional award. The period provided under Section 33 of the 96 Act for making a request for the purposes indicated above is 30 days from the date of receipt of the arbitral award, unless another time frame is agreed upon by the parties, which of course there is nothing of this case. Under subsection 2 of Section 33 of the Act, the arbitral tribunal is vested with the power to consider such requests made under subsection 1 of Section 33 of the 1996 Act, and for this purpose it has been accorded 30 days from the date of receipt of such request. This is as per the section. Then if your honor would kindly see paragraph 16. Next page. Besides this, as indicated above, the arbitral tribunal under Section 33 of the Act is also empowered to render an additional award concerning claims presented in arbitral proceedings that were not considered in the arbitral award, albeit at the request of a party made again within 30 days of receipt of the arbitral award. However, the party interested in the additional award being rendered is required to give notice to the opposite party. So, notice to the other party and within 30 days. Now, I'll straight away come to the finding at paragraph 35, which is at page 85.
Yes.
35, subclause 4. There are others also, but I'm reading only the relevant one. In the same breath, at the bottom of the page,
Yes.
where a request is made under Section 33 of the 1996 Act, it is immaterial for the purposes of computation of limitation under Section 34, subsection 3, whether such request fell within the purview of the said provision or not. What is material? This is the most relevant. What is material is only that such request was made in the manner delineated under Section 33, that is, it fulfilled the twin conditions of being made, 1, within 30 days from the receipt of the arbitral award, and 2, with notice to the other party stipulated therein. Section 33 आप दोबारा देख लेंगे, उसमें clear terms में है 30 days from the date of receipt and with notice to the other side. Admittedly, in the present case, it is not made within 30 days. It has been made more than 2 months after the date of receipt. 17/6 was their letter. 17/7 is when 30 days expired. They made it on September 22. These are the dates. And page 373 पे आपको याद होगा वो चिट्ठी है उनकी. And the Margdarshan Award also records no notice, no consent, मतलब as if जिसकी मर्जी है वो कर दे on their own accord, which is impermissible in law. The next judgment on this aspect, the Honorable Delhi High Court followed Geojit. ये Geojit भी recent judgment है. So Geojit, this is at page volume 3, I'm sorry.
Yes.
Volume 3, page 55.
Yes.
Paragraph 38. In the present case, page 55. In the present case, once the application under section 33 of the Act was filed beyond the statutory period of 30 days, the learned arbitral tribunal had already become functus officio in respect of the award in question. Consequently, the jurisdiction of the learned arbitral tribunal to entertain such application stood extinguished by operation of law itself. Then para 40, next page, in such circumstances, mere absence of objection on the part of the respondent before the learned arbitral tribunal cannot be construed as resuscitating or bringing back to life a concluded proceeding without strictly following the statutory mandate of section 33 of the Act. This would amount to conferring jurisdiction upon the learned arbitral tribunal contrary to the statutory scheme of the Act. Jurisdiction that stands exhausted by operation of law cannot be revived by acquiescence, silence, or implied waiver. A bare perusal of section 33 of the Act makes it evident that the only manner in which the period prescribed under section 33 of the Act could have been extended was through an agreement between the parties stipulating another period of time. The provision expressly contemplates that an application seeking correction or interpretation of award is to be filed within 30 days from the date of receipt unless another period of time has been agreed upon by the parties. Paragraph 44. In this view of the matter, this court of the opinion that absent a prior agreement as between the parties with respect to the time for filing of the section 33 application, the filing of the same before a tribunal which after rendering the award had become functus officio would be rendered non-est. Further, the Supreme Court in Georgie's Financial, which is the earlier judgment जो हमने आपको पढ़ी थी, has itself recognized that an application under section 33 of the Act filed beyond the prescribed statutory period would not extend the period of limitation under section 34 of the Act, which in the considered opinion of the court is what is being sought by the petitioner. Upon the expiry of the statutory period, the learned arbitral tribunal becomes functus officio, and any correction carried out thereafter, if not carried out strictly in terms of section 33, would be rendered legally unsustainable. In view of the foregoing, paragraph 49, in view of the foregoing discussion, this court is of the considered opinion that the application under section 33 is barred by limitation. Consequently, the learned arbitral tribunal become functus officio in relation to the award and therefore lack jurisdiction to entertain or allow the award. The corrected award dated 6/6/24, having been rendered pursuant to a time-barred application under section 33, is accordingly rendered legally unsustainable and non-est in the eyes of law. And therefore, at paragraph 56, it tells it is, in the next page, court is of the considered opinion present petition is clearly barred by limitation and is liable to be dismissed on the said ground itself. Then just one more judgment for the time being. If your lordship will see in volume 1, Karupia, which is judgment of the Bombay High Court. Paragraph, page number 57 पे relevant है.
Page 57
of volume 1. जी.
Yes.
Para 11. Kindly read from line 6 approximately. if after the mandate of the arbitrator is terminated and after the period of 30 days from the date of arbitral award, as contemplated under section 33 subclause 3 of the Act, any correction carried out will have no force of law being carried out by an authority which has no power. There will be thus no substitution in law.
Yes.
Neither any corrected award comes into being. Such correction will have to be ignored and will not result in any consequence. Therefore, in such circumstances, neither the original award stands corrected nor a fresh substituted award comes into being. Therefore, it cannot be said that for purposes of limitation, the corrigendum will have to be taken into consideration but discarded for the purposes of merit. As stated earlier, any correction carried out.
33(3) deals with the suo motu.
नहीं कोई they are saying any power. 33 का सारा section is like that only.
नहीं 33(3).
Yes.
It is
नहीं नहीं आई एम सेइंग दैट इज करेक्ट देयर थोड़ा सा डिफरेंस है 33 के वेरियस पावर्स में बट कॉमन एक चीज है 30 days and with notice.
You are right in saying the demarcation would be this wise. 33(1) places up the embargo in filing of the application within
Yes.
the stipulated period.
Yes.
And 33(3) clauses up a sabotaging on a part of an arbitral tribunal that you can't make out this beyond period of 30 days on your own. That is
Correct.
what- हाँ.
Yes, that difference is there, but दोनों में 30 days है. चाहे एप्लीकेशन से है, चाहे पास पे है, तो आफ्टर एन आर्बिट्रल अवार्ड इज पास अगर आपको करना है तो सो मोटो भी, योर लॉर्डशिप इज राइट, पर वो भी 30 days में है. All the parts of exercise under section 33 are 30 days for without dispute anywhere. And with notice to the other side. आप अपनी मर्जी नहीं कर सकते, आपको दूसरी साइड को मुझे सुना ही नहीं, मुझे बताया भी नहीं. I don't even know about it. I don't know about his existence. It cannot be done. So both counts, it fails. It is as if no such thing has been carried out. Your lordship is absolutely right. तो यहाँ पर they said इसमें तो again limitation में करके and thereafter if your lordship will see at paragraph 17 इसी judgment में arbitration petition will have to be rejected as barred by period of limitation. इस पर limitation alone. Notice की तो अलग बात है, वो second बात है. Now if I can just show your honor for a moment, again those two letters from the compilation. So your honor will see at page 373 is their so-called letter. Admitted dates 16/9/22 filed in the middle of the page.
Yes.
Admittedly, the earlier award received on 17/6/22, line 2. Now, if your lordship will just see the Margdarshan award at page 122. Your lordship will take it, there is no word of any notice to me.
Now, what is the meaning that they have referred inter alia the first para?
Which one?
Very first para
Of?
this letter.
Yes.
September 2022 at the preface of this particular letter. That
Yes.
is the first para itself.
हाँ जी.
Immediately beyond 17 June 2022,
Yes.
where one meeting has been referred therein.
They refer to some meeting, we have no idea. किसी ने उन्होंने तो बताया नहीं, हमने तो उनकी चिट्ठी by RTI etc. ली है. That's why how we placed it on record. They had some meeting that उनको पता होगा, we don't know.
After that, we were compelled to request the meeting with Honorable Arbiter, and fiscal hearing was conducted on the date on 22nd August 2022, in which we were asked to submit the list of items and documents.
Your Honor, this is as if the arbitrator in hand in glove with the other side is just doing all this. We don't know.
Counsel,
Yes.
the thing is, we just will have to make out this. Your key submission is with respect to the limitation.
Yes. And notice.
That is okay. Now, if you believe that 16 September 2022 is the inception where they started 33,
Yes.
22nd August 2022.
Even if it is 22nd August, firstly, we have no idea about this meeting. उनकी मीटिंग हुई है उनके साथ, that is their whatever they have done.
So you would be confining with odi alterum partum. That you
No,
are-
I am confining with limitation also and that both. Even if it is अब ये 22nd अगस्त की मीटिंग इज ऑफ नो अवेल टू बी दैट इज इट में उन्होंने ये तो नहीं कहा 22nd अगस्त को उन्होंने कोई सेक्शन 33 मूव किया है या एप्लीकेशन मीटिंग करी है तो करी है, वी डोंट नो. दिस इज देयर ओनली एप्लीकेशन ऑन रिकॉर्ड. बट इवन इफ इट इज 22nd अगस्त, आप एक मिनट के लिए विदाउट प्रेजुडिस टू माय कंटेंशन हम मान के चलिए तो क्या हो गया? इवन दैट इज आउटसाइड 30 days.
Council, you have come up with the case of limitation.
Yes.
You say that this particular initiation at their end under 33 has been time bound.
Yes.
33 is stipulating that you have to make an application within 30 days from
Correct.
passing the order.
Yes.
Now, this letter itself makes down reference of one of the date of meeting.
Right.
Now, court only wants to know about whether this is the very, now it's a question which this court will have to also adjudicate upon the point of time, whether 16 September 2022 itself is the date where this has have been made, or it is prior any other date wherein through which the AT has been approached and the application has have been preferred. Now in the event if it has been made out, then rigors would be different. Reference has been made about the meeting of 22nd August 2022 where direction has been issued. In pursuance to this, they have submitted the documents.
Your Honor, even if you take for a moment, firstly, it is for them to answer. They have not produced anything. I have produced this letter after RTI. Secondly, even if it is 22nd August, वो भी 30 दिन के बाद है. It is not their case कि उन्होंने section 33 22/8 को move किया है. It is nobody's case कि 22/8 को उन्होंने move किया. But whatever it is, आप 22 अगस्त भी ले लीजिए.
Okay, let us go. Where is their statement to the effect that they moved the application on 16 September?
No, they have not. I have filed this application in the High Court.
Who filed an application?
They have not made any date. They were asked. They were not. They have not given any date.
So there and there is no date.
There is no date. I have given their own application. This is what is there.
Fair enough.
So, अगर आप, and there is no other mention. In fact, we were constrained because there was no other choice. And अगर आप ये 122 को देखें जहां पर मार्गदर्शन अवार्ड सो कॉल्ड पास हुआ है, उसमें भी ये कुछ नहीं है कि हमने कुछ किसी को नोटिस दिया है, आर्बिट्रेटर ने मुझे सुना है, चाहे सो मोटो है चाहे एप्लीकेशन है.
Why your second contention is concerned to the effect that you are not being called upon and you not being heard?
Yes.
What is conscious to the effect that that aspect you are legitimate in raising the ground of principle of natural justice being violated?
And statutory compliance. It is as per section 33. Not only general principles, it is laid down in the statute and held in Geojit and followed by the Delhi High Court, etc.
Because if we go with the
Yes.
31, your objections are twofold.
Yes.
First objection to the effect is that as per 33(1), it is mandatory on the part of a party to file the application for alteration or additional award within 30 days of passing of the award,
Yes.
or receiving from the award. Now your
Yes.
effect is that on the 17th of June they have been received, they should file this application on 17th of July.
Yes.
In the event, if this be so, that 16 September 2022 is the only date when
Yes.
they make this particular aspect, you are right in raising this.
Yes.
But if some other date is there when this application has have been moved, then in that case, it will be arguable. I am not saying to the extent.
It is still beyond 30 days. It is still beyond 30 days. अगर आप 17 जुलाई ले लीजिए तो 22 अगस्त आउटसाइड है.
Council 22nd August is a date of meeting.
No, we can't go beyond what the.
Whether application to that extent has been filed or not, let other side actually come up with this. So
I mean, if they. I'm only saying this. अभी तक in these proceedings they have not come out with anything. ये तो हमने दिखाया है. अब जो भी डेट है ये डेट्स आपके पास है. If they are able to show anything else, अगर जो जाके anyway your honor, what I'm.
मुझे तीसरी बार वापस नहीं लाना है. Light offense.
No, your honor, that is right. That is right. बिल्कुल. I agree with you. I agree with you. Much as we like Surat and other things, but you're right. How many times will this happen? Like finally decide ho, khatam ho.
Yes.
So with this, I for the time being, I reserve my comments for rebuttal, if any.
Yes, sir. માં છે ને ભાઈ માર્કરથી આ કોનું છે ને
There are two execution applications. I appear for one. I appear for Mr. Bansal. My learned friend will appear for Mr. Jain.
Yes, I'm sorry, Your Honor. I'll just clarify one thing before my learned friend says. मैंने प्रिंसिपली बंसल के केस में आर्ग्यूमेंट की है, दूसरी आइडेंटिकल है फॉर ऑल लीगल पर्पसेस. डेट्स में एक आध में कुछ डिफरेंसेस हो सकते हैं, बट इफ योर लॉर्डशिप विल जस्ट टेक इट, द सेम आर्ग्यूमेंट्स विल प्रिवेल. वी डिडंट वांट टू डबल टाइम दैट.
ઓકે યસ
So essentially, my learned friend's argument is that section 33 timeline is mandatory. That is not followed. Therefore, the arbitrator has no subject matter jurisdiction. Therefore, it is nullity. Lordships are aware, these are execution proceedings. In execution proceedings, the scope is limited. Court will not go behind the decree. Scope is microscopic. Only if there is inherent lack of jurisdiction. That is to say that the authority does not have jurisdiction to entertain the proceedings at all. And the jurisdiction is usurped. Only then it will be inherent lack of jurisdiction. And if there is inherent lack of jurisdiction, that is the only limited scope under which objections can be raised qua a decree. I am not on arbitration. Arbitration, I am saying the scope will be even more limited. But even in a decree passed by a court, only if there is apparent lack of jurisdiction, inherent lack of jurisdiction, and that too it has to be apparent on the face of the record. Even if an inquiry is required to call out whether there was inherent lack of jurisdiction or not, that inquiry cannot be done in execution proceeding. That is the law laid down by the Supreme Court. I will take your lordship to those judgments. But this is the narrow scope in which the matter falls. I will show to your lordship, there are two awards, 6/6/2022, wherein the arbitrator decides everything. He decides that I am entitled to enhancement of compensation for land. He decides that I am entitled to compensation for trees. But he holds that it will be as per the government circular. He does not say how many trees are there. That adjudication he misses out. And for construction, what had happened was for the railway, for the national highway, my factory premises was acquired, land and constructed factory. Therefore, since day one, I had raised an objection regarding the valuation of the factory premises. Those objections were enumerated in my reference application. Those were taken before the arbitrator. The arbitrator, I will show to your lordship, the arbitrator during the course of the hearing had directed National Highway to do a joint report of the construction and submit a report before the arbitrator, which they did not permit. They did not do that, and then they demolished because in between the COVID lockdown came, so they did not do the joint report. Then they demolished the premises. It was in these circumstances that in the award dated 6/6/2022, the arbitrator directed the road and building department to do valuation of the premises and compensate me for the premises on the basis of that valuation. So an expert body was appointed. This award was never challenged, has not been challenged by them. This award, which directs valuation by R&B department and compensation as per that valuation, has not been challenged by them under section 34 or in this execution application. They have only concentrated on the Margdarshan award. They have said that the Margdarshan award is a nullity. They have not challenged the validity of the 6622 award. Pursuant to that award, the road and building department has thrice valued the property, not once, thrice valued the property. And on the basis of the valuation done by the R&B department, the Kala has calculated the compensation, which is 29th December 2022. So that direction is unchallenged, that award is unchallenged. Even if your lordship were to hold that the 33 award or the Margdarshan award is a nullity, it will have no consequence on the proceedings. All these contentions that are being raised before your lordships, these are all academic. If 66/2022 is a valid award according to them also, they are not challenging it. They are not saying that 66/2022 is also that is also without jurisdiction. That also lacks inherent lack of jurisdiction. That is not their case. So award of 66/22 will stand. That has to be executed. It directs the R&B department to do the valuation.
That has not been complained.
No, that is not challenged. They have not argued. Before your lordships, they have
That
not
has
argued
been
66/22.
no, their submission to the effect is that, that
6622 what the learned arbitrator had directed was to do valuation of the structure if any left out. That is the precise observation or finding of the learned arbitrator. So far as the market value of land
monetary
or
aspect
trees
is
is concerned, we
monetary-
have already paid. Yes.
monetary aspect is concerned, that has been completed.
Yes, trees and land. We have already paid compensation for trees and land.
So 6622 for structure it says go to the R&B. R&B will prepare the valuation report. As per the valuation report, I am to be compensated. Similarly for trees, etc. and for land. Then in the Margdarshan award, now this award is not challenged, this has become final.
એક જ એટલે કોર્ટ wants a
I will take your lordship to
એટલે
that
જ એક જ જૂન મહિનામાં જે એવોર્ડ પાસ થયો
Ji.
એના there would be three aspects on account. One, market rate compensation, that nobody is at dispute, એ payment થઈ ગયું.
ના સર એ પછી થયું હા અત્યારે થઈ ગયું છે
હા, that is
એ
one.
પેમેન્ટ થઈ ગયું.
That is one. Second, with respect to valuation of trees, numbers જોઈને કે આપે. There also, according to you, it has been done.
Pursuant
Now-
as per the Margdarshan award.
Nah.
Even
I'm sorry.
then she is making a wrong statement. Let me clarify first.
Let us make it out. Your say
I will-
has
I
been
will-
to the
yes,
your
yeah.
say to the effect is that
I'm sorry.
They
your
may,
say is that trees or you have made out the compensation for trees also.
As per
Yes.
66/2022.
Huh. 66 we are currently on 66/2022 only. We are not going to additional level. We are on 66/2022 only. According to you, because you being the employer, તમારા જ પૈસા તમારા પેલાની અંદર થાય. So let us make it down. Monetary award જે છે, acquisition rate પ્રમાણેનો જે છે, એ તમારે ચૂકવાઈ ગયું. That is one. Second, special compensation for trees. That has also been done to the effect. As far as structure is concerned, direction has been issued to the effect to make out the veracity, whether it is existing or not, and એના count ઉપર આપવાનું થાય.
my lord, my learned friend says that they have paid the compensation for trees and land as per 66/2022. I am disputing that. I will show to your lordship that it was pursuant to the Margdarshan award, not pursuant to 66/22. And I would request my learned friend to show a single document that this payment was made before the Margdarshan award. This is my case, this is her case. I'll take your lordship through every award and every detail, every document I'll take your lordship. But just briefly, what I was trying to say is, I will be responding to their contention. In reply, there are three contentions. Number one, that this entire challenge to the Margdarshan award is only an academic challenge. It has no bearing because even otherwise 6/6/2022 has to be executed. And therefore, even if there is no Margdarshan award, the valuation done by RNB pursuant to 6/6/2022 and the valuation and the compensation calculated by Kala pursuant to that valuation, that has to be given to me. That is one. On the aspect of their contention is that section 33 is mandatory. The timelines provided 30 days is mandatory. I'll take your lordship to the provision itself. The provision itself says that the parties can agree to another date. And I'll take your lordship to the latest judgment of the Supreme Court, which takes the view that 33 is not mandatory. The timelines are flexible. The parties can waive them. The parties can modify them. And then I'll show to your lordship that this is what has been done. This is not a single arbitration before this arbitrator. This arbitration is not a commercial arbitration wherein two parties agree to one arbitrator and that one arbitrator decides that only one matter. Here is an arbitrator who is appointed under section 3G5 of the National Highway Statutory Arbitration. So distinction between commercial arbitration and statutory arbitration. He sees with all the references for acquisition of district Surat. Mine is not the only singular case. Therefore, this is more like an arbitral tribunal. I show to your lordship that in more than 100 cases, after the award has been made, more than 30 days thereafter, the National Highway Authority approaches the arbitrator. No right application in writing, oral application, they hold an oral meeting, no notice to the other side. And on the basis of those oral meetings, the arbitrator has modified more than 100 awards and has thereby reduced the compensation. What I am trying to say is 33 is not mandatory. Parties can agree to a different procedure. Even under section 19 of the Arbitration Act, separate procedure can be agreed by the parties or by the arbitrator. A separate procedure has been adopted in this. The very same procedure has been followed in my case. And therefore, once there is power under 33 to modify, and I am able to show that a separate procedure has been established, which they themselves have established, they have taken benefit. Therefore, they cannot approbate and reprobate. They cannot say in 100 matters this procedure is okay, but in this one matter this procedure is contrary to law. But even otherwise, once I am able to show that, then there is no inherent lack of jurisdiction. Under 33, there is subject matter of jurisdiction. There is a separate procedure. Whether that procedure is rightly followed, wrongly followed, will make the award an irregularity, at best an irregularity, but not a nullity. That is going to be my second limb of contention. The third limb is going to be that there are judgments of 7 high courts which take a view that so far as arbitration awards are concerned, the same cannot be challenged in execution proceedings. There are 2 limbs to it. One is section 5 of the Arbitration Act, which provides that an arbitration award can be interfered with only as provided in the first part of the Arbitration Act, that is section 34. So there is bar of section 5.
Intervention of the court minimum.
Not minimum. Only it can be only as provided under the first part. First part talks of 34. Therefore, in execution, an arbitration award cannot be challenged. That is the view taken by different high courts. The second limb of that is that an arbitral award is not a decree, and arbitration proceedings are not suit, and therefore 47 itself will not apply. Section 47 applies only to decree passed in a suit. An arbitration award under 36 provides that it can be executed as if it is a decree, but it does not make it equivalent to a decree. It says it will be executed in the same manner as if it is a decree, but it does not say that arbitral award is akin to a decree. Therefore, since it is not a decree, section 47 will not apply. Those are the lines of judgment that I will show to your lordship lastly. But first on the merits. So please see the facts first. Or may I just take your lordship first to relevant provision of the Arbitration Act, and then I will take your lordship to the facts, so that the facts can be appreciated in context of the law. Lordship, may please have the Arbitration Act. Section National Highway Act Section 3G, Lordships are aware, then the jurisdiction to decide is conferred under 3G of the National Highway Act, not under the Arbitration Act. The arbitrator derived, Lordship may house National Highway Authority.
It is correct.
Yes, Section 3G5. Section 3G5 specifically confers powers upon the arbitrator appointed by the central government to decide the compensation. So, subject matter jurisdiction is with the arbitrator appointed by the central government. The central government here has appointed the collector as the arbitrator.
Authority સાચી હોવી જોઈએ એમાં બીજો પેલો ના
Therefore, he
બાકી.
has the subject matter jurisdiction under 3G5. And Arbitration Act is only the procedure to be followed. As per Section 3G5, he will follow the procedure as prescribed under the Arbitration Act. Now, please see Section 2, subsection 4 of the Arbitration Act. This part, except subsection 1 of Section 40, Section 41 and 43, shall apply to every arbitration under any other enactment for the time being in force. This arbitration is under National Highway Act, so therefore it is under another enactment. As if that other enactment were an arbitration agreement, as if the arbitration were pursuant to an arbitration agreement, and as if that other enactment were an arbitration agreement, except in so far as the provisions of this part are inconsistent with that of the other enactment or with any rules made thereunder. So, the provisions will apply provided they are not inconsistent with the National Highway Act. Then please see Section 4.
Yes.
Waiver of right to object. A party who knows that A. Any provision of this part from which the parties may derogate, or any requirement under the arbitration agreement has not been complied with, and yet proceeds with the arbitration without stating his objection to such non-compliance, without undue delay, or if a time limit is provided for stating that objection within that period of time, shall be deemed to have waived his right to object. So if they do not take objection, then it is deemed to be waived. That is the purport of Section 4. Then please see Section 32. Or before that, Section 18 may be seen, the procedure, which procedure can be adopted. The flexibility the Act gives for procedure. Procedure is not mandatory. Section 18, what is mandatory is that Section 18 provides equal treatment. The parties shall be treated equality, and each party shall be given full opportunity to present his case. So parties have to be treated equally. Then please see Section 19. Determination of rules of procedure. The arbitral tribunal shall not be bound by CPC or Indian Evidence Act. Subject to this part, the parties are free to agree on the procedure to be followed by the arbitral tribunal in conducting its proceedings. Failing any agreement referred to in subsection 2, the arbitral tribunal may, subject to this part, conduct the proceedings in the manner it considers appropriate. The powers of the arbitral tribunal under 3 includes the power to determine the admissibility, relevance, material and weight of the evidence. Therefore, parties can agree to a different procedure. If they don't, the arbitrator can. Then please see Section 32. My learned friend argued that on passing of the arbitral award, in this case 6/6/2022, the arbitrator became functus officio. But please see 32(3). Or I'll read 32(1) and then 3. The arbitral proceeding shall be terminated by the final arbitral award or by an order of the arbitral tribunal under subsection 2. Now see subsection 3. Subject to Section 33 and subsection 4 of Section 34, the mandate of the arbitral tribunal shall be terminated with the termination of the arbitral proceeding. Therefore, the mandate gets terminated subject to 33 and 34 subsection 3. Now please see Section 33. Correction and interpretation of award, additional award. Within 30 days from the receipt of the arbitral award, unless another period of time has been agreed by the parties. Therefore, the provision itself shows that it is not mandatory. A party with notice to the other party may request the arbitral tribunal to correct any computation error, any clerical or typographical error, or any other error of a similar nature. B. If so agreed by the parties, a party with notice to the other party may request the arbitral tribunal to give interpretation of a specific point or part of the award. Subsection 2. That not relevant. 3. The arbitral tribunal may correct any error of the type referred to in subsection in subclause A of subsection 1 on its own initiative within 30 days from the date of the arbitral award. 4. Unless otherwise agreed by the party, a party with notice to the other party may request within 30 days from the receipt of the arbitral award the arbitral tribunal to make an additional award as to claims presented in the arbitral proceedings but omitted from the arbitral award. Again, it starts with the word unless otherwise agreed by the party. Therefore, even this is subject to agreement of the parties to the contrary. The arbitral tribunal may extend, if necessary, the period of time within which it shall make a correction, give an interpretation, or make an additional arbitration award. And 7. Section 31 shall apply to correction or interpretation of the arbitral award to an additional arbitration award under this section. Therefore, 33 3 powers: correction, interpretation, additional award. All within 30 days or otherwise agreed by the parties. Therefore, the timelines are not mandatory, they are flexible and can be altered by the parties or the arbitrator, and I'll show to your Lordship that they have been altered. Then Lordship may say 34.3 because that expiry of mandate was also subject to 34.3. So even if after the award is passed, 33 is exercised or not exercised, 34 is filed, even at that stage the mandate is not terminated. And 34.3 says an application for setting aside may not be made after 3 months, 33.4, subsection 4. On receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party, adjourn the proceeding for a time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitration proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the award. Therefore, even after 30 days, 33 is not exercised. 34 is filed. Long after that also, while 34 is going on, the court can adjourn the proceedings so that the arbitrator has an opportunity to correct the award. So there is no immediate expiry of mandate, or that expiry of mandate is not immediate on completion of 30 days period. It is subject to 33, it is subject to 34.3. 33 itself is not mandatory, and a separate procedure has been agreed to. That is what I will now be showing from the facts of the case. But this is the law, essentially this is the law. Now please see, in my Lordship may first have the darkhast, the original execution application, because I said that I have sought execution of not only the Margdarshak award but also of 6/6/2022.
તમારો નંબર કયો છે 153?
દરખાસ્ત 153 153. છે કોપી છે દરખાસ્ત. May I just pass on a copy? Lordship, may just note paragraph 1. The decree holder prays for execution under Order 21 Rule 10 of CPC and under Section 36 of Arbitration and Conciliation Act, the award order dated 6/6/2022. Particulars are as follows. Then in the particulars, please see column 3, row 3, date of the award and date of order, 29/12/2022, 6/6/2022 and 21/10/2022. 6/6 is the first award, 21/10/2022 is the award that they say is pursuant to 33, and 29/12/2022 is the computation made by Kala. It is not an arbitration award, but he computes, the computation aspect was left to him, so that he has computed the figures.
અહીંયા તમે ડિમાર્કેશન ક્યાં કર્યું છે? છઠ્ઠા જૂનની એવોર્ડનું વેલ્યુએશન જે તમને નથી મળ્યું,
સાહેબ આર્બિટ્રેશનમાં તો દરખાસ્તમાં તો હોય જ નહીં. I am only
તમે
saying-
નીચે કર્યું છે પર્ટિક્યુલર્સ ઓફ ડિગ્રી આર એઝ હવે
Yes.
તમે એમાં ઇન્ટરેસ્ટ માંગ્યું છે પેલા પાછળ
Lordships are referring.
એડિશનલ કોમ્પોનન્ટ તમે પાછળ જાઓ બી
I understand. Valuation of arbitration.
therefore payment has been made 6/6/2022 માં payment has been made. હવે જે આ દરખાસ્ત તમારે you are claiming interest on the additional thing, meaning thereby કે જે બીજા કોમ્પોનન્ટ છે એ પે થઈ ગયા.
એ મેં રિમાર્કેટ કર્યું છે. પ્લીઝ સી પર્ટિક્યુલર્સ ઓફ ડિગ્રી એઝ અંડર રોમન 4 પછી there is a table particular
That
of
is what I am
degree.
saying. તમે એમાં બી માં જાઓ
હા,
પાછળ
A is the total amount which was
હા, હવે
determined.
પછી બી માં જાઓ
B માં 9% interest per annum on additional compensation granted by the arbitrator 6/6 till date.
that means 6 જૂન 2022 નો જે એવોર્ડ છે your submission would be કે they complied partly, એમણે પૂરેપૂરું નથી કર્યું. their say to the extent is bearing the structural aspect, everything is okay. Now only thing would be this wise, how much would be the actual sum that was uncontroverted, that court has to decide for the reason there is a issue between the parties. એક જ મિનિટ માટે સમજો. say for example there would be 3 components. One, market rate compensation for the acquisition, compensation for the trees, and compensation for the removal of the structures.
Correct.
Now on that particular aspect, precisely, if I'm still not, as far as area acquisition is concerned, market rate compensation might have been paid by them. Probably speaking,
It is paid. As per
Then-
my instruction, it is paid.
now your say is that for trees also, uprooting of trees also, it might not have been paid on account. Their say is that
No, I'm saying they have paid it, but they have paid it after the margin.
so
At that time your lordship
Okay,
query
okay.
was after 6/6. They said after 6/6. I said no, after margin.
what is assessing it of the facts on account? Now firstly speaking, it will be tiered up in 2 parts. One, award dated 6 June 2022.
Correct.
And second one, the additional award.
Additional.
We are on the 6 June 2022
Yes.
for the reason you say that enforcement to the extent in absence of 34 would definitely invite action on the part of the court. Now that is your say. Now for that particular aspect, court wants to know what is the real sum for which you say that this is uncontroverted for the reason of setting aside arbitral award application not being filed.
Correct.
So these requires to be looked into.
Yes.
કે
So-
6/6/2022 માં આટલો એવોર્ડ થાય એમાં એમણે આટલો પે નથી કર્યો. That is what court wants to know.
એટલે એમાં I have mentioned
Your
the
Lordship is absolutely right. I mean that 6/6/22 without anything has to be dealt with.
so 29 crores 47 lakh 43,757 is the total compensation payable to me as per the arbitral award. Interest is 5 crores. Then I say that total becomes 35 crore 36 lakhs, and then D, previously paid by NHI, I say 2 crores 3 lakh has been paid. This is towards the land and the trees. And therefore the amount which is now payable is 33, 32, 29,045. 33 crores is what is payable now.
So according to you,
Yes.
the captions that have been left out have been the interest for the additional component.
The additional component and the interest minus 2 crores which they paid, that is the amount which is now remaining.
એટલે 6/6/2022 જે એટિમોલોજીકલી આઈ એમ સેઇંગ એટિમોલોજીકલી એ એવોર્ડ તો પે થઈ ગયો.
સાહેબ એમાંથી જ આ રાઇઝ થાય છે 6/6/22માંથી જ આ અમાઉન્ટ રાઇઝ થાય છે.
I say I reserve your caveat on account કે સ્ટ્રક્ચરલનું પેમેન્ટ તમારા કહેવા પ્રમાણે જે એમણે ડાયરેક્શન આપી એ લેફ્ટ આઉટ થયું. લેટ અસ ગો ધી એવોર્ડ લાવું છે.
યસ.
એવોર્ડ ક્યાં છે?
Therefore, if your lordships have my reply, એમને જે
We
એપ્લિકેશન
continue at 245.
lordship
એવોર્ડ
immediately after this I'll take your lordship to the facts and the award itself, lordship.
એટલે આ what I want to show is
The clarity as to what was awarded
see
in what.
no, we take out side by side three things. One, what AT awarded. Second, how they complied. And three, what according to you has been left out to be looked into. Now, if that be so, anything that is left out to be at the very instance on the 6/6/2022, where they had a notice and they failed to take out action under 34(3), you have a cause. But for the reason that you made an application.
વીસના રોજ નોટિસ પાઠવી પ્રથમ સુનાવણી 17/2ના રોજ રાખી વખતો વખત સોએન્સોના રોજ COVID-19ના લોકડાઉન કારણે સુનાવણી બંધ રાખ્યા બાદ લોકડાઉન ખુલતા 24/8/2020 તથા 8/10/2020ના રોજ ઝાડ કે મશીનરી સ્ટ્રક્ચર બાબતે જે ક્લેમ છે તેથી વિશેષ કે ઓછો એક્વાયર થયા છે કે કેમ
the High Court, we were to deal with the purport of the Margdarshan Award and Section 33 issues. We are entering into another domain. I don't, ultimately, your Lordship has.
Court is getting the issue. These things are going to overlap.
No, they may. But for a moment, first, only one.
Counsel, wait for a while. Your prayer to the extent is that this execution petition requires to be quashed. His say is that even if hypothetically it has been believed that additional award cannot be considered, his say is that 6th June award has not been complied by you. What is bound to
No, I'm saying you may, but could you look it up separately because it will just confuse.
That is different aspect. Your principal prayer, is execution petition requires to be quashed. Now, if that requires to be quashed and you want, I understand. You are inviting the adjudication on the objection. What will
Yes.
Now, your adjudication to that extent would be make, if I allow the objection, the consequential thing would be either rejection of the execution petition. Now,
No, I understand. But
his say is this wise, and that's why court is making it down and narrowing the bridge whether 6th June 2022 award has been complied in spirit or not. Then
but the first, no, I understand. But the issue today, with your Lordships, the matters were remanded.
Allow court to look into this wise.
No, I'm saying see it some other time, no difficulty, but finish one issue because it will just confuse the issue. I understand. मैं मना नहीं कर रही. I'm just saying kindly.
Court is not going to be confused. It is at the instance of the court only that this aspect is.
No, of course. I'm sorry. I don't mean the court is confused. I'm saying we don't want. We only want the issue of 33 to be decided. You decide that and the Margdarshan Award, and
Again, court is just making it down that your objection precisely has been to the effect that this execution does not require to be, you yourself said that this not sustainable on account. Now he said to the effect is that if over and above the additional award 6 June 2022 has not been complied. At least look, allow the court to look into them straightway 2 rigors that you have argued that he has said he will come out. Yes.
So my Lord, Lordships have seen for structure, there was a direction to the RNB to do the valuation and compensation was to be paid accordingly. Then my Lord's page
So if I
9
am not mistaken, qua area wise market rate has been concerned, there is no dispute or the difference that has been complied with and NHAI has made out the payment. So two disputing items would be to the extent of the payment of the trees
that is
and
also
the
paid.
structure.
That is also paid.
Tree
That is-
also has been
has
paid.
been paid.
It's only on account to the
Structures,
structures
which they are
wherein
not.
through which this has been left out to be repaid.
So in 6.6 your Lordship has seen that there was a direction to RNB to do the revaluation and I was to be compensated accordingly. Now please see the final conclusion hukam which is at internal page 9. Number 1. બ્લોક નંબર 93-98 વાળી જમીન જેનું પ્રાથમિક જાહેરનામું સો એનસો દિવસે ખેતીનો ભાવ હું સો એનસો નક્કી કરું છું. So therefore in first he decides the market value of the land which has been paid by them. Then my lords may see number 3. અરજદારો વૃક્ષો માટેનું વળતર સરકારશ્રીના સો એનસો પરિપત્ર પ્રમાણે મેળવવા હકદાર રહેશે. That has been computed by Kala, that has been paid. Now see 5. અરજદારો જમીન, બાંધકામ, વૃક્ષો, અન્ય કોઈ પણ પ્રકારના નુકસાનનું વળતર જે નક્કી થાય તેના ઉપર કલમ 30(1) મુજબ 100% સોલ્યુશનની રકમ મેળવવા હકદાર છે તેમ ઠરાવશે. Therefore, since the construction figure he had not arrived at, it was to be determined by the RNB. Therefore, that after it is done, 100% solution on construction on the market value of construction is also awarded.
This aspect has not been looked into.
Yes, this construction, the compensation for construction and solution for construction has not been paid. That is the principal grievance. So this is the award of 6/6/2022, under which there is a direction to the RNB to value the construction and to the Kala to pay me compensation accordingly. Now please see what happens thereafter.
You received this on 17 June. That is not disputed. Award.
Yes,
On 17 June you received the award.
yes.
And then you applied to 80 on which date?
Lordship may see my reply at Exhibit 53. I have put in the entire chronology and I have made the amendments on
53?
both. Exhibit 53.
Yes.
Then my lords, on internal page 8, your lordship will find a chronological date-wise events.
Yes.
Lordships can ignore the first 4 events. Then my lord, 1410 etc. that is relating to the other matter wherein awards were passed by the very same arbitrator for the very same acquisition. Other lands for the very same acquisition, which were amended. Those awards were amended at the behest of National Highway on oral request after period of 30 days. But I will come to that later. Right now, lordships are on the award and how.
So precisely speaking, your representation, whichever mode, has been on the 22nd of August.
Lordship.
Correct?
No, I'm sorry. On 17/6, I received, if your lordship sees on page 10, internal page 10, 6/6 is the award which I just read. Then on 17 June 2022, I say respondent received a copy of the arbitration award. As per the practice and procedure, within 2 weeks of the receipt of award, the respondent in person approached the arbitrator for clarification. He was asked by the office of the arbitrator to come on 22nd August 2022. One Mr. Tushar Vyas, project director and representative of NHAI, was present all throughout. Then on 22nd August 2022, the respondent appeared in person before the arbitrator. The arbitrator asked
एक minute. You received the award.
on 17,
That is not a dispute.
lordship.
This is the practice that you are saying.
Yes, which I will establish later on.
That is
Correct.
secondary aspect.
Correct.
assertion of the claim formally lodged before the tribunal, that date, see, it would be on account of adjudication of the dispute.
Lordship.
Now your assertion that requires to be looked into, that you formally gave before the tribunal for adjudication.
Lordship.
That date is crucial.
So that
According
date I
to
am
them
saying.
is a 16th September. Now according to you, if it means that the meeting, then it is 22nd of.
No, according to me, after receiving on 17/6, I approached the arbitrator orally because that was the procedure. I was appearing in person. I followed the procedure which was prevailing before the arbitrator.
What would this be? This oral appearance and all that, Bloods? This is something which is going to be heard, Bloods.
If my learned friend gives me the opportunity, I show to this honorable court that in 100 awards, they have made oral request and the awards have been
Fair
given.
enough.
That doesn't mean that they made it.
Therefore, to say what is this oral? This oral
Right.
is a practice which has been established by
Fair
them.
enough.
So I'm sorry. This is not something which can be argued like this.
Interrupt, I'll permit you to make a rebuttal.
And I have
Yes,
been
yes.
keeping on record, I have made averments. They have had
I'll
opportunity
permit you
deal with
to
it.
make a rebuttal.
Yes.
Yes.
So 17 I received. Thereafter, within 2 weeks, I approached the arbitrator. I was asked to remain present on 22nd. On 22nd, again I approached the arbitrator. The arbitrator hears what the issues on which I need clarification. After that, he says that put them in writing. Therefore, on 15/9/2022, I put them in writing. 15/9/2022, as directed by the learned arbitrator, respondent submitted in writing the issues on which the modification clarification of the award was sought. Mr. Tushar Vyas, project director and representative of NHAI was present. Copy was provided to hearing. No hearing was conducted by the arbitrator as per the practice and procedure. Then, my lords, we see on 21/9/2022, the learned arbitrator sought some clarification from R&B department. On 22nd September 2022, the executive engineer R&B department informed that the original valuation relied upon by Kala in his award was prepared by National Highway Authority and not by R&B department. It is pertinent to mention that a copy of this communication was marked to NHAI. Thus, NHAI was aware about the proceedings. Please see this letter, 22/9/2022. It is at page 102 in that compilation.
Yes.
Yes. 22/9/2002.
Yes.
22. This is by Karyapalak Engineer, Marg and Road and Building Department. The arbitrator sought a clarification from them. Okay, whether they had earlier performed the valuation or not. They said no, the earlier valuation was by the National Highway Authority. But please see, Vishay, Messrs Bansal Building Material Private Limited, arbitration હુકમ અંગે રજૂઆત બાબતે કલેક્ટર્સ કચેરીના પત્ર ક્રમાંક નંબર 21/9/2022. So after the 6/6/2022 award, અત્રેની કચેરીનો પત્ર 9/9/2019. Then see મુદ્દા નંબર 5, 6, these are the clarifications that he gives. More importantly, Bidana. And then Nakal Jai Bharat Sir Ravana Prati Project Director National Highway Authority of India PIU Surat so and so. Therefore, the arbitrator on my application for clarification, which I say a copy was given to the National Highway Authority, the arbitrator seeks some clarification from R&B department. R&B department replies to it and marks a copy to the National Highway. Therefore, National Highway was aware that these proceedings are going on, that some clarifications have been sought. They do not choose to
But
object
even
to
then, this is 22nd September.
This is 22nd September. And thereafter the Margdarshan Award is passed. So before passing of the Margdarshan Award, this communication has gone to them. Then, my lords, on
For
15th.
passing of Margdarshan award is a different.
Huh.
Your filing of application, that is what I am saying. It is subsequent to this.
No, my filing of application is prior.
17th.
My filing of application is 17th June.
Ah,
Not June.
September.
September.
So it is
15th
subsequent.
15th September is the
so
date
it is
of my
subsequent to
application.
this.
My application, my written application, I approached orally. I was asked to remain present. I remained present on 22nd August. Then I was told to give in writing. I gave it in writing on 15th September. After that, the arbitrator seeks clarification from R&B department. R&B department gives that clarification on 22nd September. So subsequent to my 15th September. My application date, written application date is 15th September. This is subsequent to that. On 22nd September, this clarification is made by R&B and a copy is given to National Highway. And then on 22nd October 2022, the Margdarshan or the clarification, the section 33 award is passed. That is on 21/10/2022. That your lordship will find page 11 of the compilation.
Yes.
21/10/2022 is the date. પ્રસ્તુત બાબત વિષય અત્રેના આર્બિટ્રેશન હુકમ અંગે માર્ગદર્શન આપવા. પ્રસ્તુત બાબતે અત્રેના આર્બિટ્રેશન કેસ 6/18 તથા 7/18ના કામે અત્રેથી 6/6/22ના હુકમથી આર્બિટ્રેશન કેસનો આખરી નિકાલ કરવામાં આવેલો. ત્યારબાદ અરજદાર દ્વારા માનનીય કલેક્ટર સુરત રૂબરૂના અર્થઘટન બાબતે નીચેના મુદ્દાઓ ઉપર જરૂરી માર્ગદર્શન આપવા રજૂઆત કરેલી, જે અંગેનું માર્ગદર્શન આપવામાં આવે છે. Therefore, this is the Margdarshan award. Now, before that, please see my application of 15th September.
Yes.
15th September, wherein I have mentioned that I had approached earlier and I was told to come on 22nd.
ત્રણસો બોતેર પર છે ને કયો નંબર?
હાજી,
હા, ચાલો
372 છે ને?
373 ચાલો. યસ, પ્રોસીડ.
Just the first, the order was received from Honorable Arbitrator's Office dated 6/6/2022, received on 17/6 due to discrepancy, omission, errancy in the order. After that, we were compelled to request a meeting with the Honorable Arbitrator. So when I say that within 2 weeks I approached them for a meeting, that is also mentioned here. And we were compelled to seek a meeting, and physical hearing was conducted on 22nd August. So I was told to remain present on 22nd August. On 22nd August, in which we were asked to submit list of item document which error was left out and mistaken in the order. We are very grateful, appeased that we are able to discuss our concern, problem, issue, case matter with Honorable I. We therefore are submitting the list of documents. So this is 15th September. Before that, I had approached. I was asked to remain present on 22nd. On 22nd,
Now these are the additional items you.
yes, on which I had sought clarification, and on which the clarification of
Now
the
you show
Margdarshan.
that for these additional award meetings,
Yes.
representative of NHAI was present, their response was being sought. Any minutes of tribunal?
Nothing. I have aware that Tushar Vyas, who is the project director, was present when I first approached the arbitrator. I have also aware that on 22nd also he was present, and on 15th also he was present. But the arbitrator has not, from the arbitrator who do not have any minutes which records all this. I have said this on affidavit in my reply, that he was present. That I have just read out to your lordships, those events, that he was there and we had given him a copy. That I have said in my affidavit.
So if I have understood your submission, it is twofold. Firstly, speaking to you, there is no delay as such, as you approach the AT immediately after passing of the award.
Award, correct.
Orally, you raised the contention on account to look into. You then formally had a meeting with them. You narrated your say by raising an application that according to is a practice and the custom, you will show
Yes.
how that has been going on. That is first aspect.
Yes.
Second would be to the effect that even if it is being considered that 16 September has been there, section 33 is not mandatory in the context of the case, for the reason being with the synchronization this is going on.
Yes.
That has been the
Yes.
two aspects.
Yes.
Okay, further.
Yes. Now may I just complete the chronology, how thereafter they have participated in the proceedings and what has happened, and then I will take your lordship to the how this procedure has been established. So, 660. Then my lord, એટલે 21/10 આપણે બતાવ્યું. Lord, it is not in dispute. They themselves have stated in their letter that on 17th November 2020, November 2022, I say Margdarshan Award was received by NHAI. The said fact is recorded in letter of NHAI dated 20th December 2022. NHAI chose not to challenge it and the same has attained finality. Then on 9th December 2022, the executive engineer R&B department prepared and submitted its valuation report as per the direction of the learned arbitrator, and the copy was also marked to NHAI. Please see this report of 9th December 2022. It is at page number 16.
Page number
16 of my list of
60.
116.
Yes.
This is by the Karyapalak Engineer. Date is 9th December. It is addressed to Khas Jamin Sampadan Adhikari, that is the Kala. વિષય આર્બિટ્રેશન કેસ નંબર સો એન્ડ સો બાબતે સુધારેલા વેલ્યુએશન રિપોર્ટ મોકલવા બાબત આપશ્રીની કચેરીનો સો એન્ડ સો તારીખ 21/10/2022. ઉપરોક્ત વિષય પરત્વે અંગે સંદર્ભિત પત્રના અનુસંધાને સવિનય જણાવવાનું કે આર્બિટ્રેશન કેસ નંબર 6/18ના કામે વેલ્યુએશન રિપોર્ટમાં રહેલ ક્ષતિ બાબતે નીચે મુજબના મુદ્દા અંગે માર્ગદર્શન આપવા માટે રજૂઆત કરવામાં આવેલી હતી, જે અંગેની અત્રેની વિભાગીય કચેરીએ લાગુ મુદ્દાઓની પૂર્તતા કરી જૂના નેશનલ હાઈવે ઓથોરિટી ઓફ ઇન્ડિયાના વેલ્યુએશનને આધારે તથા સંદર્ભિત પત્રની સૂચનાઓ ધ્યાનમાં લઈ જરૂરી સુધારા વધારા સહિતની નવા વેલ્યુએશન રિપોર્ટની નકલ આ સાથે સામેલ છે. સદર રિપોર્ટ અંગે NHAI તરફથી જરૂરી માર્ગદર્શન મેળવવા વિનંતી છે. બિડાણ નવો વેલ્યુએશન રિપોર્ટ, ફોટોગ્રાફ, રેટ એનાલિસિસ એટસેટરા આર ઓલ ધેર. દેન નકલ જય ભારત સાથે સવિનય રવાના પ્રતિ કલેક્ટર સુરત એન્ડ ધ નેક્સ્ટ નકલ જય ભારત રવાના પ્રતિ પ્રોજેક્ટ ડાયરેક્ટર નેશનલ હાઈવે ઓથોરિટી. So this valuation report is also given to the national. They are also aware of this. The proceeding all along which culminated into 2912, the computation of 2912. Earlier also the communicate, they were in the loop. Now this report is prepared, which is also provided to National Highway Authority. Next page is the report. Not necessary to go into that, but then the entire report is there. Then my lords, on 29th December, after the valuation is done by the Road and Building Department, on 29th December 2022, Kala computes the compensation, and that your lordship will find at page 26.
Yes.
On the top, the date is mentioned 29th December 2022. Your lordship may just notice વંચાણે લીધું. Number, item number 2 is 6/6/2022 મૂકા. Then my lords, item number 7,
NHAI later.
NHAI. 8 is 21/10/2022, the Margdarshak Award. Then item number 9 is the valuation by the R&B department, executive engineer R&B department's valuation, dated 9th December 2022. And that, my lords, on the next page, on the first page, Amuk Dema, he discusses the award of 6/6/2022. Then on the next page, Amuk Bena Hukam Margdarshan આપવા રજૂઆત કરતા આર્બિટ્રેટર સુરત દ્વારા અમુક આંખથી જરૂરી માર્ગદર્શન આપતા ઉક્ત માર્ગદર્શનના મુદ્દા નંબર 5ની વિગતે અરજદારની જંત્રી દર બાબતની રજૂઆત કરતા અત્રેના હુકમ શરત ચૂકતી ખેતીની જંત્રી સને 2011ની સ્થિતિએ 708 ગણી હુકમ કરવામાં આવેલો, પરંતુ સદરુ બ્લોક પૈકી 100ની ખેતીની ઓનલાઈન જંત્રી 785 ચોરસ મીટર છે, જ્યારે બ્લોક નંબર 93ની ખેતી અને 2019ની ઓનલાઈન જંત્રી 835 પ્રતિ ચોરસ મીટર છે, જે વેબસાઇટ ઉપર ઉપલબ્ધ છે. જેથી બ્લોક નંબર 100 ના સમયગાળા દરમિયાન જમીન જંત્રી દર 835 પ્રતિ ચોરસ મીટરમાં 10% લેખે 31 માસનો 25.83 વધારો આપતા ખેતીની જમીનનો ભાવ ₹1050 યાની 1051 પ્રતિ ચોરસ મીટર પ્રમાણે ચૂકવવા જણાવું છું તથા બિનખેતી જમીનમાં કિસ્સામાં ભાવ ખેતીની જમીન કરતાં બમણા એટલે ₹2102 પ્રતિ ચોરસ મીટર આપવા જણાવું છું. What had happened was in the 6/6/2022 award, the jantri was taken as ₹708 for agriculture land and then it was doubled for non-agriculture land. But then in the Margdarshan award, the arbitrator clarifies that that was a mistake. It is not 708, it is 785. So therefore that amount is corrected for the land and that amount they have paid. And then my lords, if your lordship sees the patrak, at page 33,
Yes.
the construction, the amount which comes for construction has been mentioned. And at page 34, the land amount is mentioned. And page 66, the compensation for the trees is calculated. Page 36.
Patris.
Yes. Yes, page 35, sorry, page 35, trees, compensation for trees. And then my lords, on next page, the total amount. બાંધકામની રકમ, બાંધકામની કિંમતના તફાવત મુજબની રકમ, સેકન્ડ લાસ્ટ કોલમ, 9,99,13,438. So this is the calculation 29th December 2022, which is also subject matter of execution, because the award only said by entitlement, calculation was done in this manner, which is also I am seeking execution of this also. Then my lords, after this Kala award is, this Kala does the computation. On 7th February 2023, again in the chronology I have mentioned this, the project director of National Highway Authority of India holds a meeting with the arbitrator and orally requests for review of valuation of the structure. And considering this oral request, the learned arbitrator directed R&B department to review the valuation. But this is evident from the letter of Kala of National Highway Authority dated 15th February 2023. And my lords, this shows, now this request is also after 30 days of the award. It is also oral. It is also without notice to me. They request the arbitrator to review they request the arbitrator to ask the R&B department to review the valuation, and the arbitrator grants them that request. Please see the letter of 15th February 2023, which is at page 50. Again, this shows two things. They were aware about the proceeding. They did not object. After the Kala award is passed, they themselves seek review of the proceedings. And that is also by the same method, oral request, no notice, no hearing, and order of the arbitrator. Please see, this is a letter of National Highway Authority. It is dated 15th February 2023. Subject is reference to verification of valuation of structure for survey number so and so. Reference Collector Surat guidelines number so and so dated 21/10/2022. This office letter dated 20th December 2022. Then they say, dear sir, this is in reference to the discussion held with Collector and District Magistrate Surat, who is the arbitrator. So National Highway Authority is writing to the Executive Engineer, R&B department, that they had discussions with the Collector Surat or the arbitrator in presence of the representative of R&B department during the meeting dated 7th February 2023. During the above said meeting, we have informed our representative and reservations and shortcomings regarding the valuation received after getting vetted from R&B department Surat. As per Government of India policy regarding land acquisition under the National Highway Act, it is clearly stipulated the valuation has to be worked out on the basis of SOR applicable as on the date of the preliminary notification, which has to be then depreciated based on the age of the structure. As on 3-year notification, SOR which was in force was of 2015-16 and same has to be considered. Any market rate cannot be considered over the SOR rate. Also, any development of structure subsequent to the date of the preliminary notification has to be ignored. In the recent valuation vetted by R&B, there has been huge variation in the quantities when compared with the earlier valuation which was also vetted by R&B department. Accordingly, it was decided to review such quantities and to neglect any unjustified increment. As increase in the quantity may please be done by furnishing justified reasoning. Also, there is no provision of annual increment before the same has to be executed from the valuation. Moreover, any damage done to the land has to be duly factored in while by determining the compensation amount. It is learned that the landowner has extracted ordinary earth soil from the acquired land which has created negative value of the acquired land. Accordingly, the same should be deducted in the valuation. Please see paragraph 4. In view of the above, Collector Surat, who is the arbitrator, has asked your representative to review the valuation, thanking you. Therefore, my lords, in this letter, NHI says that on 7th February 2023, NHI had an oral meeting with the arbitrator in presence of a representative of the Road and Building Department, and in this meeting, the arbitrator has asked the representative of R&B to review the valuation. This is what this letter of NHI record. So even after the passing of the computation award, they have sought review of it. That was without any notice to me. That was oral request, and that oral request was granted, and a second valuation was done by the R&B department, which your lordship will find first in my chronology, in my reply. My averment is at page 12, 7th March 2023. Page 11 bottom, my averment regarding this meeting of 7th February. And then immediately thereafter, 7th March 2023, based on the letter of NHAI dated 15th February 2023, Executive Engineer.
The very letter that you read?
Yes, that letter your lordship will find at page 51. Letter I have read, then as per that letter, the Executive Engineer Marg and Makan Vibhag on 17th March 2023 sends his second valuation report. He sends it to the collector, who is the arbitrator. Again, Vishay arbitration case number 6 અને 7 of 2018 ના કામે સુધારા valuation report મોકલવા બાબત. And he refers to the letter of the National Highway Authority dated 15 February 2023, which I just read out. ઉપરોક્ત વિષય સંદર્ભિત પત્રના અનુસંધાને જણાવવાનું કે આર્બિટ્રેશન કેસ નંબર 16 કામે કલેક્ટર સુરત તારીખ 7/2/2023 ની મીટિંગમાં થયેલ મૌખિક ચર્ચા તેમજ સંદર્ભ દર્શિત પત્ર નંબર 1, that is NHAI's letter of 15 February 2023 માં દર્શાવેલા મુદ્દાને ધ્યાનમાં લઈ SOR 2015-16 મુજબ સુધારેલા વેલ્યુએશન રિપોર્ટ જરૂરી આધાર પુરાવા તથા ફોટોગ્રાફ જોડી આ સાથે સાદર કરવામાં આવે છે, જે વિદિત થવા વિનંતી છે. Then my lords, in the Bidar, the valuation report is there, rate analysis, જરૂરી આધાર પુરાવા, photographs, and a copy is sent to the National Highway Authority. Copy is marked. On the next page, your lordship will find the report. In the just notice the last column, remarks. Quantity as per old NHAI valuation report, SOR item change. Everywhere the same quantity has been accepted which was given by NHAI in its valuation report in 2018. They have only applied the correct SOR rate. That is what the R&B department is saying. There is no change in quantity. Quantity is adopted as per the old NHAI report. In every item this observation was
SOR only is changed.
Yes, only the SOR has been changed. What had happened is when they made the valuation before the Kala award in 2018, they made a valuation through a private valuer. That private valuer, he measured the quantity We said that a lot of quantity has been left out, but R&B department only considered the quantity which was recorded in their valuation. But in their valuation, he had mentioned the construction taking into consideration the concrete grade used for residential premises. Mine was an industry. It was an export-oriented unit. There the SOR rate are different.
Fair enough. Valuation report આવ્યો પછી?
Yes. એટલે આ valuation report એમનો આવ્યો. પછી lordship may see, going back to my chronology, after this valuation report, and there is no substantial change. What is important is that in this second review, there is no change in the amount. And then, my lords, they make part payment. That is important. After this second valuation, on 5th April 2023, NHAI deposits part of the enhanced compensation with competent authority for payment to the respondent. Thus, the Margdarshak award was accepted by NHAI. That letter, your lordship will find at page 62.
Yes.
It is dated 5th of April. It is to the competent authority. And please see, dear sir, kindly refer to your arbitration award of 31st December 2022. Compensation amount of rupees 3.43 crores is approved by RO Gandhinagar, dated so and so, dated 27 March 23, against arbitration award of village Moti Naroli, Taluka Mangrod, Surat. Then, my lords, there are certain aspects which we are not concerned with that. It is also to convey that the competent authority NHAI has considered the compensation of trees as per the Panchkyash of 8.1, duly considering the rate of GOG circular. Also, the valuation of structure has been considered per original award. This is for your information. You are requested to make the disbursement of compensation on urgent basis. So, on the award of 10 crore plus, they deposit 3 crore 43 lakhs. Part payment they deposit before the Kala and ask the Kala to disburse it to us. And my lords, please see who has signed it. It is signed by Tushar Vyas, the project director, which in my averment I have said he was present all along in all hearing. I have specifically named him. This is signed by Tushar Vyas, project director. And then, my lords, after this amount is received by Kala, the Kala on 9th May 2023 disburses this amount to us. That your lordship will find at page 65. Seventh May 2023. This is by Khas Jamin Sampadan Adhikari. And at the end, your lordship will find the amount paid to us. NHAI deposited 3 crore 43 lakh 77,905, out of which 2 crore 3 lakh was paid to me, Kamlesh Murarilal Barsal, and 1.39 crore was paid to my learned friend's client, Nikhil Bhavarlal Jain. So part award complied, and now they want to say that for the balance amount, they want to say that this is without jurisdiction, nullity, non-est, etc. Then, my lord, on 1st June 2023, which is at page 69, Kala writes to the project director, National Highway Authority, for the balance amount. Just please notice the last paragraph. Arbitration Conciliation Act 1996 ની કલમ 30 ની જોગવાઈ અધીન મહેરબાન આર્બિટ્રેટરથી આર્બિટ્રેશન એવોર્ડ જાહેર કરવામાં આવેલ. ઉક્ત કાયદાની કલમ 33 ની જોગવાઈ અધીન સંદર્ભ 1 મુજબનો સુધારો હુકમ કરવામાં આવેલો. ઉક્ત બંને એવોર્ડની નકલ આપને પણ બજાવવામાં આવેલ છે. આર્બિટ્રેશન એક્ટની કલમ 34 ની જોગવાઈ અધીન આપના દ્વારા ઉક્ત બંને હુકમને પડકારવામાં આવેલ નથી, જેથી આપના દ્વારા હુકમ ન પડકારવાના સંજોગોમાં આર્બિટ્રેશન એક્ટની કલમ 35 મુજબ આર્બિટ્રેશનના હુકમને આખરી તથા બંધનકર્તા બને છે, જે મુજબ ઉક્ત એવોર્ડનો અમલ ફરજિયાતપણે કરવાનો થાય છે. સબક હકીકત સત્વરે અત્રેના સંદર્ભ 2ના પત્રથી મોકલવા આમેલ 9% વ્યાજ ચૂકવવા અંગેના એવોર્ડને મંજૂરી આપી વળતરની રકમ અત્રે જમા આપવા વિનંતી છે, જેથી અસરગ્રસ્ત ખાતેદારોને વળતરની રકમની ચૂકવણી કરી શકાય. વધુમાં સદરુ બાબતે વારંવાર પત્ર વ્યવહાર ટાળી આર્બિટ્રેટરશ્રીના હુકમની અમલવારી કરવા જણાવવામાં આવે છે. And then, my lords, 9th August 2023, again Kala writes to National Highway Authority to deposit the balance amount. 9th August is the page, next page, page 71. It is to the project director. Reference is arbitration case number 6 and 7, which is our case. And it is in response to their letter dated 23rd May. He says, with reference to the subject matter cited above, I would like to bring to your notice that the order of the learned arbitrator dated 6/6 was issued after hearing both parties and has not been challenged by any of the parties in the competent appellate court till date. In the said order on page 7 in para 2, it says, ખાતેદાર સાથે કાર્યપાલક ઇજનેરશ્રી માર્ગ અને મકાનની સંયુક્ત સ્થળ વિઝિટ રાખી કોઈ સ્ટ્રક્ચરનું વેલ્યુએશન એવોર્ડ સમયે ગણતરીમાં લેવાનું રહી જવા પામેલ હોય તો નિયમ અનુસાર સ્ટ્રક્ચરની વેલ્યુ ધ્યાને લેવાની રહે છે. Accordingly, Road and Building Department has submitted a revised valuation report dated 9/12, based on which the revised proposal was sent for approval. Moreover, during the said hearing, the learned arbitrator had asked for a joint survey to be conducted during 2 hearings dated 8/10/2020 and 23rd November 2020, which were not complied with by the NHAI. This request was made as the initial valuation report was prepared by a private agency appointed by NHAI, and the applicants had objected. The officials of the Road and Building Department had only verified the valuation report based on prevailing SOR, as the joint survey could not be made during the course of the hearing. Hence, the final arbitration award directed the RNB to carry out survey along with applicant. No new order was issued by the learned arbitrator in this regard. The arbitration award did direct to calculate depreciation based on the representation made by NHI during the course of hearing, but after the order was issued, a representation was made. The NHI also agreed to calculate structure valuation in Valsad district without depreciation, after which this issue was verified by the learned arbitrator in Surat, with that in Valsad by letter dated 18/10/2022, after which the said clarification letter was issued on 21/10/2022. It is a basic principle that there should be parity in policy for all cases of land acquisition across districts for the same project. As far as legality of the clarification is concerned, similar clarifications were issued in different cases for the same project dated 16th September 2021, when references were made by this office to the learned arbitrator, and the same clarification were accepted by NHAI. Again, the principle of parity must apply in all cases. Essentially, my lords, he is saying 3 things. That during the arbitration proceeding itself, the arbitrator had asked for a joint report for the structure, which NHAI did not comply. Therefore, the NHAI had passed in 6/6/2022, NHAI had passed the direction that the RNB should now make the valuation and I should be compensated accordingly. With direction he has reproduced in Gujarati, in this letter itself he has reproduced. Then he says that accordingly RNB has now made the valuation and that amount has to be paid. That is what he specifically says. And then in the last paragraph he says that similar awards have been modified and those modifications you have accepted, and therefore there has to be parity and you have to accept this. This is what he says, Kala. Pursuant thereto, again the National Highway authorities, then they approach directly the Secretary of Road and Building Department. Until now the arbitrator had directed the Road and Building to do the valuation, which was done. Then National Highway Authority through the arbitrator sought a review, that was also done. Now at page 72, National Highway Authority directly approaches the Secretary Road and Building Department and requests for revaluation of the very same structure. Please see 17th October 2023. This is by National Highway Authority to the Secretary Road and Building Department. Subject: verification of structure, valuation in block number 90, village Moti Naroli. With reference to the above cited subject, this is to bring to your notice that land bearing block number so and so, district Surat have been acquired under National Highway Act, issued an award under so and fixed the valuation of structure existing on the land at so and so.
And then fresh valuation is done.
Yes, please see paragraph 5 directly. In view of the above, it is requested that necessary direction may be issued to the concerned officer to re-verify the structure valuation to avoid infructuous expenditure of the government money. Even this request was accepted, and on the next date, on the next page, 30th December 2023, the executive engineer Surat again does valuation. So this is the third time the valuation is done. 30th December 2023. Executive engineer to collector and district magistrate Surat.
How much he quantified?
Same count. Amount is same. There is slight deduction. Now please see what he says. He refers to the 17/10/2023 letter of NHAI to the secretary. Then he says, with reference to the above subject matter, it is to inform you that arbitration case number was in progress at your office. Main matter of arbitration case was difference between given valuation and real site situation and contains many mistakes. While the proceedings of arbitration case and during the proceeding of the arbitration case, NHAI officials were ordered multiple times to conduct a joint visit with the RNB official and NHAI valuation consultant in order to study the site situation and to verify the claim of the applicant. This office had written many letters. Reference 1 is the letter of 9/9/2019. So by letter of 9/9/2019, RNB had written to NHAI office to schedule joint visit, but joint visit was not arranged. During proceeding of the case, compliance report for remark, NSO and so report was sent. It was mentioned that once NHAI prepares modified report, etc. Please see the last two lines. After re-verification, some arithmetic corrections are done and comparative statement of both new prepared by RNB and old prepared by NHAI with reason of change is attached herewith, including all necessary photographs, quotations as per SOR rate. The differential amount between both the valuation report is also mentioned in comparative statement. As the report was made on order of your office, it is requested to take opinion of NHAI as implementing agency. And the copy is marked to NHAI, and then your lordship will find the report. And the last page of the report, the total amount now is 8.97 crores. Earlier it was 9 point something crores. Now its few lakh has been reduced. That is page 84. In the last column, your lordship will find total difference 8 crore 97 lakh 49,710.
Yes.
So my lords, 6/6/2022, lordships have seen there was a direction for the road and building department to value, and I am to be compensated accordingly. Thereafter valuation was done. They were in the loop of the entire proceeding. They chose not to challenge 6/6/2022. That has become final. Margdarshan award is passed. They were present. There also copies were marked to them. They have not challenged those proceedings. They had not objected to the proceeding. Thereafter, Margdarshak award was passed. Thereafter, the RNB department has done the valuation on the basis of which the Kala had computed the total compensation on 29th December 2022. Thereafter, they sought review of the valuation. The arbitrator granted the review. Again, valuation was done by RNB department. And thereafter, they made part payment. Thereafter, they again requested the secretary of the RNB department to conduct the valuation again, which has also been done. So thrice the valuation has been conducted by the RNB department, which is a agency of the state, an independent authority and an expert in this field. authorized valuation has been done pursuant to the order of 6/6/2022, and the amount which we are seeking in our execution is the amount as per that valuation. So now, my lords, on the aspect of 33, I'll first kindly see how the very same arbitrator in other references arising from the very same acquisition, how those awards were modified, whether there was this procedure or not, and whether I am able to show on record that this procedure was there. Lords, may please see on 14/10/2021, if your lordships goes back to my chronology, which is at page 8 of my reply.
Yes.
Page 8, the first date is 27th November 2023. Notification was published under 3A of the National Highway Act for acquiring the land of the respondent number 3, who is a decree holder now, and in all 63 persons of village Moti Naroli. Therefore, the acquisition was for 63 persons. Then, my lords, the award was passed by Kala. Then on 21st August 2018, I had filed those references seeking enhancement for compensation of land, building and trees. That reference is also produced. Then, my lords, on 12th September, acquiring body, that is Ministry of National Highway, appointed the collector Surat as the arbitrator under section 3G. On 14/10, now please see on 14/10/2021, in the case of the other persons whose land was acquired along by the same notification, mine was NA land having construction of factory building, therefore it was separated from the other matters. In the other matters, an award is passed on 14/10/2021, which is award number 46. In other 43 cases of same village Moti Naroli arising from the same acquisition proceeding, arbitrator passed an award number 46 of 2018 enhancing the compensation. Please see that award your lordship will find at page 167. I have produced the award.
This is also beyond 30 days of.
Yes, I'll show your lordship. It was beyond 60 days in fact. And it was also oral. And it was also without notice. Everything that they have objected to, now they are objecting. They have established this practice and they have taken the benefit of this practice.
Okay.
So 14/10/2021 is the date of this award. If your lordship sees the number of Arajda, so these are 43 cases. This is not done in 1 or 2 cases. This is 43 cases. Now please see at page 207 the amount of compensation that was increased. Page 207, last column, final entry. Your lordship will find the amount 61,46,09,281. Therefore, this, by way of this award, a sum of rupees 61 crore was payable to those 43 persons. That was their enhanced compensation. This is the award passed by the arbitrator.
If I have understood, your purpose of referring this is to the effect that with concurrence, the parties had decided that they can move under section 33 application before the arbitrator beyond period of 30 days.
Yes.
This has been happening in other cases.
Yes.
So this can well be in this case also.
Yes. So, on lordship saw the award of 14/10/2021, that is by the arbitrator. That is qua 43 reference application filed for the lands acquired by the very same notification under which my land was acquired. So in 43 he enhances the compensation. That amount comes to 61 crores. Now please see what happens on 7th, how this has been amended. 7th of January 2022, page 210, a Sudhara award is passed by the very same arbitrator. Lordships have page?
Yes.
Yes. So page 210, date is 7th January 2022. Please just note સુધારા હુકમ વશી 56 of 2022 because there are two Sudhara award. This is number 56 of 2022. 7th January date is there. વાંચ્યું અત્રેના આર્બિટ્રેશન હુકમો, નોટ વન મેની ઓર્ડરો, અત્રેના આર્બિટ્રેશન હુકમો નેશનલ હાઈવે ઓથોરિટીના પ્રોજેક્ટ ડાયરેક્ટરની મૌખિક રજૂઆત, પ્લીઝ નોટ ધીસ, મૌખિક રજૂઆત તેમજ ખાસ જમીન સંપાદન અધિકારી શ્રી શાખા નંબર 1 સાથે થયેલી ચર્ચાઓ. નો મેન્શન ઓફ નોટિસ એટસેટરા ટુ ધ લેન્ડ ઓનર્સ. સુધારા હુકમ ઉપરોક્ત વિષય અન્વયે અત્રેના જિલ્લા માંગરોળ તાલુકા સિયાલજ તથા મોટી નરોલી ગામોના આર્બિટ્રેશન કેસોના હુકમોમાં ગામવાર ચૂકવાયેલ મહત્તમ જંત્રીને ધ્યાનમાં લઈ તેના પર સને 2011ની જંત્રી અમલમાં આવ્યા તારીખથી પ્રાથમિક જાહેરનામાની તારીખ સુધી વાર્ષિક 10% વધારો ધ્યાને લઈ તેની બજાર કિંમત ગણી વળતર ચૂકવવા હુકમ કરેલ હતો. સો અર્લિયર ધીસ વોઝ ધ મેથડ. જે અંગે નેશનલ હાઈવે ઓથોરિટીના પ્રોજેક્ટ ડાયરેક્ટર શ્રી સાથે થયેલ ચર્ચા મુજબ તથા જ્યાં જંત્રી દર સરેરાશ વેચાણ દર 708થી વધારે છે તેવા કિસ્સામાં જે તે બ્લોક નંબરવાળી જમીનનો ખરેખર જંત્રી દર સરેરાશ દર ધ્યાને લઈ તેને સને 2011ની જંત્રીની સ્થિતિએ બજાર કિંમત ગણી સને 2011ની જંત્રીનો અમલ આવ્યા તારીખથી પ્રાથમિક જાહેરનામાની તારીખ સુધીનો વાર્ષિક 10% વધારો ધ્યાનમાં લઈ તે મુજબ બજાર કિંમત ચૂકવવા જણાવતો આ સુધારા હુકમ કરવામાં આવે છે. So please note, he in the first paragraph he mentions that in his earlier award he had directed the land value to be calculated in a particular manner. Then he says that on oral request and oral discussion with the National Highway Authority, he is passing this Sudhara award and he is changing the method of computing the land value. This is 3 months after. This is dated 7th January 2022. The award was of 14th October 2021. So 3 months thereafter, he passes a Sudhara award, which is on the basis of an oral request of the National Highway Authority. There is no notice or hearing to the other side. And there is no written application, despite which this clarification, Sudhara award, whatever is passed. And please see what is the effect of this Sudhara award. That your Lordship will find at page, I'm sorry, this is not the only Sudhara award. Then on the very same day, he passes another Sudhara award, which is on the next page. 211, sorry. Again it is dated 7th January, but see the number, Sudhara Vashi 57 of 2021. That was Sudhara Vashi 56.
86 દિવસ.
હા 56 ના પેલો સાહેબ 56 નંબરનો સુધારા હુકમ હતો. after 86 days. Yes, both are after 86 days. એમાં બી વંચાણે અત્રેના આર્બિટ્રેશન હુકમ નેશનલ હાઈવે ઓથોરિટીના પ્રોજેક્ટ ડાયરેક્ટરની મૌખિક રજૂઆત તેમજ અધિકારી સેમ રીતના and there he reduces the rate of interest. By this Sudhara હુકમ he says કે earlier I had said કે 9% પહેલા વર્ષે, પછીના વર્ષ માટે 15% વ્યાજ આપવાનું, એના બદલે હવે ફ્લેટ 9% કરી કાઢ્યું. But what is the combined effect? Now please see, after this, at over the page number 212, after this Sudhara Hukam is passed, on 31st January 2022, National Highway Authority writes to the Kala and he says कि Sudhara Hukam प्रमाणे वो तबे recompute करो calculation, compensation. So he writes to Kala, the subject is differential arbitration award to be declared as per the order of the arbitrator. Difference award of village Moti Naroli, Kuwada in Mangrol Taluka. Reference, then my lords, he refers to the Sudhara award of 56 dated 7/1/2022, Sudhara award order number 57 of 7 January 22, and then my lords, he says this office is in receipt of the differential award declared as per the arbitration order for Moti Naroli, Kuwada village of Mangrol in Surat video letter under reference number 1. Further, learned arbitrator and collector issued correction order cited under reference 3 and 4 above. You are requested to make necessary changes in the differential award incorporating the direction mentioned in Sudhara order regarding compensation of trees. The NHA has already communicated by letter dated so and so, which may be taken into consideration. Now please see, on the basis of this Sudhara award, Kala recomputes, that is at page 214. That recomputation is of 4th of February 2022. આખું સાહેબ નથી વાંચતો, ખાલી વંચાણે લીધુંમાં 2 નંબર ઉપર Lordship will find the arbitration award dated 14/10/2021. Okay, this was the award. Then my lords 8 and 9 are the Sudhara award which he considers. 7/1/2022 ના હુકમ નંબર 100 સુધારો 57 of 2021 અને 56 of 2021. And on that basis he modifies the computation. Please see how the compensation is thereby reduced. After this hukam is at page 5, from page 6 the computation starts, internal page 6, and at the end of this, that is at page, please see page 226, the last column, last entry. Now the compensation payable to those 43 person is reduced to 30,40,34,731. સાહેબ 30 કરોડનું કમ્પેન્સેશન આ રીતનું ઓછું થયું છે અને આવું 43 જણામાં આ કરવામાં આવ્યું છે. When I say that this arbitrator, this is not a single arbitrator being decided by this arbitrator. બધા ગામના મોટી નરોલી, કુવાડા, સિયાલજ બધા ગામના રેફરન્સીસ એમની જોડે હતા અને બાકી બધામાં આ પ્રોસિજરથી એમને મારવમાં સુધારો થયો એ પહેલાંથી કરેલા છે. સો ધીસ વોઝ ધ પ્રોસિજર વિચ વોઝ ગોઈંગ ઓન ધેર કે ઓરલ રજૂઆત કરે, એમને એ લાગે યોગ્ય, કોઈને હિયરિંગ નહીં, ઓરલ રજૂઆત સાંભળે પછી એમને યોગ્ય લાગે એ પ્રમાણે એ સુધારા એવોર્ડ કરતા હતા, મોડિફિકેશન્સ કરતા હતા. આ એક કેસ થયો 43 જણાનો. આવો સાહેબ પછી શિયાલજનો છે. શિયાલજમાં બી
You can only give a reference
Yes.
if it is the same.
may I just give the my averments. I'll just show from my averments. Lordship may go back to my reply. Just see my averments on page 9, 14/10/2021, award number 46 of 2018 in other 43 cases of same village Moti Naroli arising from the same acquisition proceedings. Arbitrator passed an award on 46, award number 46 of 2018, enhancing compensation. Then on 26 November 2021.
What aspect come? You
Yes.
showed the reduction also, that is there
That
on
is
7
the
January on 2020.
for the other villages. Please see paragraph 9.6 and 9.7 of this reply. I'll read from paragraph 9.5. The applicant is objecting to the award dated 21/10/2022 on the ground that the award is nullity, as arbitrator had become functus officio. They were not served with a notice prior to the award. Award is after a period of 1 month, etc. I state that such objection involve inquiry of fact and can be subject matter of challenge under 34 of the Arbitration Act only, and having not done so, the award cannot be challenged on such grounds in execution, and the same is barred by section 5 of the Arbitration Act. Even otherwise, by virtue of section 3G, the arbitrator has the power to determine the compensation. By virtue of section 33, the arbitrator has power to correct mistake, give clarification, and even pass an additional award. Thus, the award is not without jurisdiction and is not a nullity. As stated above, the NHAI and the arbitrator have determined procedure for such arbitration, whereby awards are modified on oral request of NHAI made after 30 days of award and without notice or hearing to the other side. In the very same acquisition proceeding undertaken by the same notification for other agricultural land in the same village, similar procedure has been adopted by the applicant NHAI for modification of the arbitration award. The applicant under the same acquisition has acquired other land of same village Moti Naroli. The arbitrator wide award dated 14/10/2021 passed in LAQ number so and so Moti Naroli Nangrod 46 of 2018 and other group matter decided more than 43 reference and determined the market value of the land to be 1051 per square meter. On the basis of the award dated 14/10/21, Kala passed the order dated 26/11/21 determining the amount of compensation payable, which as per the table annexed total to an amount of rupees 61 crore 46 lakhs towards the land involved therein. The director of applicant NHAI made oral request and pursuant to oral discussion with Kala without any notice to the owners, the arbitrator passed two amendment awards on 7/1/2022, modifying the earlier award, changing the manner in which the market value was to be considered. The applicant communicated this amended award to Kala on 15/1 and asked to make necessary changes in the differential award. Accordingly, Kala, by an order dated 4th February 2022, modified the amount of compensation payable, which was reduced to 30 crores. Now 9.7 is for the other. Similarly, in other acquisition cases also, the arbitral awards have been amended by the arbitrator pursuant to oral request of NHAI, and compensation amount have been reduced. To avoid burdening the record, copies of the said award were not placed hearing, but I crave leave to produce the same at the time of hearing if required, details of which are followed. I have produced that also, and I'll give the
Yes,
lordship.
after the table,
Yes.
what you have content, you come straight.
Yes.
Page
So-
number 18.
So what your lordship will see, first is Mangrove, Moti Naroli Mangrove.
I have understood.
Yes.
તમે table પછી આવી જાઓ. It is submitted.
It is submitted that the arbitrator is unilaterally appointed by the acquiring body. The procedure of arbitration has been fixed by NHAI and arbitrator. The applicant NHAI has benefited from such procedure and has got awards modified on oral request in numerous cases. The very same procedure has been adopted by the respondent. The applicant therefore cannot be permitted to challenge the award on such ground when it has accepted other such amendment, markdashas, clarificatory award passed at its oral request when it is benefiting out of such correction. Such contradictory and onerous stands are not expected from a state who is required to act in a fair, reasonable, equitable manner. In fact, Kala has also appeared in present execution proceeding and filed its reply. Thus, in view of what is stated here, application is even otherwise meritless and is required to be rejected on this ground itself. Now, my lords, these three other awards, one is again of Moti Naroli. There, the original award of 29/10/2021, the compensation was 24 crores 76 lakhs 76 lakhs.
Reduced.
It is reduced to 20 crores. I have produced those award. If your lordship wants, I can give the page
It
number.
may well be when it is reduced, they are ready.
Yes. and all these awards I have placed on record. If your lordship wants, I can give the page number of these awards. This 24 crore award, your lordship will find at page 327. Lordship may just note the page number. And thereafter, the reduced award,
Page number.
page number 327 is the first award of 24 crores, dated 29/10/2021. Then, my lord, the amendment and award that 7th January your lordships have already noted, which is at page 269. And then the amount is reduced to 20 crores, which your lordship will find at page 355. Then, my lords, the second pertains to Kuvarda, village Kuvarda. There, the original award was, first award determined by the arbitrator was 28 crores 71 lakhs, which your lordship will find at page 243. Sorry, 273. And, my lords, then, as per those Sudhara award, it was reduced to 27 crores, which your lordship will find at page Kuvarda છે ને that your lordship will find at page Kuvarda is at 315, and the reduction of amount your lordship will find at page 323. And then, my lords, the third is of Shialaj village, which the original arbitration award is of 12 crores, which is at page 229, and the reduced is at page 363.
There you are not, amount has not been.
That
there.
amount we have not
Okay.
at the time of filing
Fair
the reply, but
Yeah.
we'll inform subsequently. So this is the practice which is going on. This is the practice. This is the procedure. This has been followed by National Highway Authority. They have got the awards modified in this manner, and the very same. And this was prior to my case. It is not after my case. All these awards have been modified earlier, prior to my case, and the same procedure has been followed. That is what I was trying to show. Now, in this connection, lordships have already seen section 33. Section 33 says that the party can agree to a different timeline. The party can agree to a different procedure. Section 19 of the Arbitration Act also says that the parties can agree to a different procedure. And if the parties, in absence of such agreement, even the arbitrator can set up a different procedure. Therefore, the procedure is not mandatory. Section 33 confers subject matter jurisdiction or powers upon the arbitrator to modify, clarify, and even pass an additional award. So subject matter jurisdiction is there. Their contention is that these timelines are mandatory. I am saying that the provision itself says that the timelines are not mandatory. Parties can agree to some different timelines. And now please see the Supreme Court judgment on this issue, whether these timelines are mandatory or not.
I'm sorry, my lords. Is my learned friend through, my lords?
No.
Oh, sorry. I thought your lordship was looking for me.
He is on verge of culmination.
Well, as much he's been for a bit, it's all right. He has a audio alterum partum is the right he has.
And yeah, I'll permit you.
Yes, 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 yes.
But probably since he has now gone to authorities, hopefully your term will soon start.
Only thing is, lords, we might need to carry it over. Let's see.
Yeah.
Well, the first judgment that I am relying upon, Amnapi, 2025, 7 SCC, page 132, North Delhi Municipal Corporation. That is judgment. My learned friend has cited judgments on 33. None of those judgments say that the procedure of 33 is mandatory. The timelines is mandatory, and in breach thereof, the award is nullity. That finding your lordship will not find in any of those judgments. Most of them were in proceedings under 34. None of them in execution. As I said, the scope in execution is even limited than 34. But none of those judgments says that it is mandatory, and breach results in nullity. That is nowhere the finding of the Supreme Court. Now please see here, Lord, here the arbitration award was passed on 16 December 1997. That your lordship will find in paragraph 5 of the judgment. In 2005, the arbitrator issued clarification to the effect that post-award interest has to be paid on the awarded amount plus interest pendant light. That clarification came in the year 2005, that is in para 15. So the clarification was after 8 years. This was challenged in execution on the ground of nullity. The single judge of the High Court declared it a null and void award. Division bench confirmed that order. Supreme Court reversed those both orders and remanded back the matter. And in the second round, this discussion of what is the effect of 33, etc. has been discussed. Please see para 53 to 55.
Yes.
If your lordship wants the date of the original award and the date of modification or clarification of the award, lordship will find the date of the award in paragraph 5. Somewhere in the middle.
We are more concerned with...
Yes, so this was after 30 days. In fact, it was after 8 years. That is what I am trying to say. Now please see paragraph 52. I'm sorry, 53. 52 onwards I'll read. 52, lordship will find section 33 is reproduced. Then 53. As per subsection 1 of section 33, within 30 days from the date of the receipt of the arbitral award, a party with notice to the other party may request the arbitral tribunal to correct any computation error, any clerical error. Further, if the parties agree, a party with notice to the other party may request the arbitral tribunal to give an interpretation of a specified point or may stand extended or part of the award. The period of 30 days contemplated under subsection 1 may stand extended to other period of time if agreed upon by the parties. Therefore, ordinarily the time limit for correction of errors or for interpretation of a specific point or part of the award is 30 days from the date of receipt of the arbitral award. However, the limitation of 30 days can be waived for another period of time if agreed upon by the party. Question for consideration is what has been agreed upon by the parties as appeared in subsection 1 of section 33. Subsection 7 of section 33 clarifies that correction or interpretation of arbitration award or passing of additional award would attract section 31 of the 1996 Act as discussed supra. Therefore, the language of subsection 1 of section 33 makes it abundantly clear that the period of 30 days as provided in section 33(1) is not an inflexible period. If the parties agree, the said period can be extended. There is no dispute to the proposition of law laid down in Harshad Chimanlal Modi relied upon by the appellant that where a court has no jurisdiction over the subject matter of the suit by reason of any limitation imposed by the statute, charter or commission, it cannot take up the cause or matter. An order passed by the court having no such jurisdiction is a nullity. Question is whether such a proposition would have any application to the facts and circumstances of the present case. As we have seen, there was no embargo on the arbitral tribunal to exercise jurisdiction over the subject matter. Same case here, there is no embargo on the subject matter. 3G confers that power, 33 also confers that power. The only limitation was that the correction and or the interpretation of the award should be done within 30 days from the date of receipt of the arbitration award, unless another period of time has been agreed upon by the parties. Therefore, the expression, unless another period of time has been agreed upon by the party, assumes critical significance. Now please see paragraph 61, 61, 62, 63.
Yes.
The learned arbitrator issued the clarification on 15th March 2005. It was clarified that the amount awarded along with the interest for the pre-reference and pendant light period becomes the decretal amount as per section 31(7)(b). This amount would carry further interest. Thus, the learned arbitrator clarified post-award interest shall be payable on the awarded sum, that is the amount of claim plus interest for the pre-reference period and pendant light up to the date of the award at the rate mentioned therein. The appellant did not challenge the clarification dated 15th March 2005 under section 34 of the 1996 Act. Instead, the appellant questioned the same in execution proceeding before the learned single judge. The learned single judge, in his order dated 19th February 2008, held that the learned arbitrator had become functus officio and thus had no authority to entertain the application for clarification. The learned arbitrator in his award has granted simple interest on the awarded amount, that is the principal amount from so and so to actual, which takes care of the interest. The decree holder neither challenged the award nor sought clarification within 30 days. It is also not the case where the award debtor, the appellant herein, has agreed for extension of time limit. Holding that the learned arbitrator had no authority to make any change in the award, the learned single judge set aside the clarification. When the respondent approached the division bench asserting the above decision of the learned single judge, the division bench wide order dated so and so, that in view of the judgment of SL Arora, compound interest under 1996 Act cannot be granted. Accordingly, the challenge to the decision of the learned single judge was rejected. Paragraph 64. When the matter came up before this court, in civil appeal number so and so at the instance of the revenue, this court observed that the decision in SL Arora has been overruled in Haider consultancy, declaring that the interest component payable to the respondent shall be computed in accordance with the law laid down in Haider. Both the orders of the single judge and the division bench were set aside, further clarifying that it would be open to the respondent to seek execution as per the law pronounced by this court in Haider. So single judge said that it is the arbitrator had become functus officio, he had no jurisdiction, award was a nullity, clarificatory award was a nullity, and he had set aside. That order was set aside by the Supreme Court. Thereafter, the executing court, that is the learned single judge, passed the order dated so and so. The learned single judge firstly held that it was no longer open to examine the question as to whether the respondent had any right to approach the learned arbitrator to seek clarification, or whether the learned arbitrator had become functus officio. The division bench had expressly permitted the respondent to seek clarification from the arbitrator, which decision was not interfered by this court. Then, my lords, may see para 68. The issue raised by the appellant in the present proceeding, that the learned arbitrator had become functus officio and therefore had no jurisdiction to issue the clarification, was also raised in the earlier miscellaneous application filed by the before this court seeking clarification of the order dated so and so, 13th March 2000. While dismissing the miscellaneous application, no leave was granted by this court to agitate the aforesaid issue in any other proceeding. Therefore, viewed from this perspective also, it is not open to the appellant to raise the aforesaid issue again in the present proceeding. In view of what we have discussed above, the interpretation given by us to section 33(1) of the 96 Act and on the cumulative assessment of the attendant facts and circumstances of the case, we are of the view that the clarification sought for and issued by the learned arbitrator would be covered by the expression unless another period of time has been agreed upon by the parties appearing in section 33(1). This is a case where the court had permitted respondent to seek clarification upon the learned beyond initial period. Therefore, the present case would be covered by the above expression in the circumstances contention that the learned arbitrator had become found and therefore lacked jurisdiction to issue the case cannot be accepted and is thus rejected. Therefore, my lords, it clearly says that the timelines are not inflexible. They can be waived, they can be modified. In my case, I am showing that they have been waived. A separate procedure was established by the NHAI itself and it had taken benefit of that procedure. Same procedure has been followed. Even otherwise, by not challenging this, they have waived any objection to it now. And since these are not mandatory, these timelines are not mandatory, breach doesn't result in nullity. Under section 3G5, the arbitrator has subject matter jurisdiction to decide the amount. Under section 33, he has subject matter jurisdiction to give clarification, modification, and even pass an additional amount. So subject matter jurisdiction is there. Now, 33 is not mandatory. Timelines in 33 are not mandatory. I am showing existence of circumstances that a different procedure is being followed in this arbitral tribunal. That is at the behest of NHAI itself. Therefore, there is no lacuna in the award. But even if there is lacuna, since there is no subject matter, lack of subject matter jurisdiction, even if there is breach of those timelines, then it does not amount to nullity. At best, it becomes an irregular or an illegal order, which can be set aside in 34, but not in execution. In execution, only an order which lacks inherent jurisdiction, and that lack of inherent jurisdiction has to be apparent on the face of the record. One does not have to make an inquiry to call out the lack of jurisdiction. Only then the court will interfere in execution. Otherwise, 34 was the remedy. They could have gone and challenged it in 34. They have chosen not to do so. They are in execution proceedings today. I am showing that 33 is not mandatory. Timelines in 33 is not mandatory. I am showing that there is a different procedure adopted by this arbitral tribunal, which they have taken benefit of, which is at their behest. Therefore, there are circumstances to believe that they have agreed to this. Lordship will not go into the factual inquiry whether it amounts to waiver in this case or not, because Lordships are now exercising powers under in execution proceedings, limited scope. Therefore, that inquiry will not go. I just need to show the circumstances, and the matter should end there. That there is subject matter jurisdiction, there is no inherent lack of jurisdiction, and therefore, the award on the grounds on which they have challenged, those grounds cannot be entertained in this execution proceeding. That is the submission based on this. Now, the second judgment that I want to realize, 2023 SCC Online 1378.
2023
SCC Online, Supreme Court 1378. Mumtaz Waqaf. My lord, here the issue was that the Waqaf tribunal passed an award that was not challenged under 34. In execution, it was challenged on the ground that the Waqaf tribunal did not have jurisdiction, subject matter jurisdiction. Therefore, it was a nullity. Execution court rejected that contention. High Court allowed the challenge in CRA, but Supreme Court reversed the order of the High Court in SLP. Now, please see paragraph 12. Your Lordship will find the plea of nullity was taken in paragraph 12. Shri Sham Diwan, learned senior counsel appearing for the contesting respondent, submitted that a plea of nullity can be taken at any stage, as held in so and so section 6 and 7 of the Act, do not confer the requisite jurisdiction on the Waqaf tribunal in deciding an issue via an eviction of an individual from a Waqaf property, as the impugned order was passed, noting the dictum laid down by court in Ramesh so and so, there is no need for interference. So the plea of nullity was taken that the Waqaf tribunal had no jurisdiction. Now please see paragraph 5, 15 and 16.
Yes.
Executing court cannot go beyond the decree. That is what the Supreme Court says in bold handwriting. The legal principle that an executing court cannot go beyond the decree stands fortified, subject to the rigors of section 47, read with order 21 of the code. As a matter of course, an executing court is enjoined with the duty to give effect to the decree. Any interference, including on a question involving jurisdiction, should be undertaken very sparsely as a matter of exception. The onus lies heavily on the judgment debtor to convince the court that a decree is inexecutable. When an exercise is likely to involve a factual adjudication, it should better be avoided. The conduct of a party assumes significance. If a party is likely to have an undue advantage, despite the availability of opportunity to raise a plea of lack of jurisdiction at the earlier point of time, it should not be permitted to do so during the execution proceeding. In other words, a plaintiff shall not be made to suffer by the passive act of the defendant in submitting to the jurisdiction. One has to see the consequence while taking note of the huge pendency of the cases before various courts in the country. There is no gainsaying that but for the adverse decree suffered, a judgment debtor would not have ventured to raise such a plea. It is clearly a case of an afterthought to suit his convenience. He cannot be allowed to approbate and reprobate, though he was conscious about the earlier proceeding dealing with the stage at which such a plea can be raised. Much water has flown under the bridge. Though we are conscious about the earlier precedents dealing with the stage at which such a plea can be raised, much water has flown under the bridge in terms of the ground reality. Then, my lord, on approbate and reprobate, on the next page, these phrases are borrowed from Scott law. They would only mean that no party can be allowed to accept and reject the same thing, and thus one cannot blow hot and cold. The principle behind the doctrine of election is inbuilt in the concept of approbate and reprobate. Once again, it is a principle of equity coming under the contours of common law. Therefore, he who knows that if he objects to an instrument, he will not get the benefit he wants, cannot be allowed to do so while enjoying the fruits.
Fair enough, it is explained.
So
the
they have
doctrine of estoppel that is being
appropriate. So they have taken benefit in the other case, and now they are objecting. Therefore, I am invoking this principle. And my lords, this so paragraph 15, 16, and my lords, only that one line at the end of paragraph 16. Okay, though we are conscious about the earlier precedent dealing with the stage at which such a plea of nullity can be raised, much water has flown. Earlier the courts were allowing it in execution, but the court is saying that now much water has flown, and now it cannot be done so. And then the principle of approbate and reprobate. That is the second judgment. Then, my lord, the third judgment that I will be relying upon is Vasudev Dhanji Modi, a three-judge judgment, 1970, Volume 1, SCC 670.
yes.
Paragraph 5, this is a three-bench judgment. Paragraph 5 to 9. This takes the view that objection as to jurisdiction cannot be taken for the first time in execution proceedings. Want of jurisdiction must be apparent and no inquiry is required to come out. In paragraph 5, in this case, the suit for ejectment against the Munshi was instituted by Modi in court of small cause. No objection was raised that the court had no jurisdiction to entertain the suit. The objection was not raised in appeal, nor before the High Court. The trial court dismissed the suit on merits. The decree was reversed by the district court, and that decree was confirmed by the High Court. The objection was raised for the first time when the decree was sought to be executed. A court executing a decree cannot go behind the decree. Between the parties or the representative, it must take the decree according to its tenor and cannot entertain any objection that the decree was incorrect in law or on facts until it is set aside by an appropriate proceeding in appeal or revision or decree. A decree, even if erroneous, is still binding between the parties. When a decree which is a nullity, for instance, where it is passed without bringing legal representative on record of a person, who was dead at the date of the decree, or against a ruling prince without a certificate is sought to be executed, an objection in that behalf may be raised in a proceeding for execution. Again, when the decree is made by a court which has no inherent jurisdiction to make objection as to its validity, may be raised in an execution proceeding. If the objections appear on the face of the record, where the objection as to jurisdiction of the court to pass the decree does not appear on the face of the record and requires examination of the question raised and decided at the trial, or which could have been but have not been raised, the executing court will have no jurisdiction to entertain an objection as to the validity of the decree, even on the ground of absence of jurisdiction. My lords, paragraph 8, last 4 lines. If the decree is on the face of record without jurisdiction and the question does not relate to territorial jurisdiction, under section 11 of the suit, objection of jurisdiction of the court to make the decree may be raised, where it is necessary to investigate facts in order to determine whether the court which had passed the decree had no jurisdiction to entertain and try the suit. The objection cannot be raised in the execution proceeding.
Fair enough. Your say to the effect is that in your this
The
particular
33
case,
confers
it is
the
not a
power.
functus officio.
Yeah.
There is no lack of inherent jurisdiction.
Yes. And this inquiry therefore cannot be made, whether it became functus officio or not. Once there is subject matter jurisdiction, once there is a procedure and that procedure is followed, this inquiry, whether it became functus officio, etc., all those inquiries cannot be now made. Then, my lords, third is 1999, 1 SCC, page 558, Bhavarlal Bhandari. My lords, here, curiously, the decree was passed after period of limitation, and that was challenged in the execution proceedings on the ground of nullity, that since it is beyond limitation, it is nullity. Now please see paragraph 10. The aforesaid decision of this court squarely applies to the facts of the present case. This is not a case in which the award decree on the face of it was shown to be without jurisdiction. Even if the decree was passed beyond the period of limitation, it would be an error of law, or at the highest, a wrong decision, which can be corrected in appeal proceedings and not by the executing court, which was bound by such a decree. It is not the case of the respondent that the court which passed the decree was lacking inherent jurisdiction to pass such a decree. This becomes all the more so when the respondent did not think fit to file objection against the award, which was sought to be made the rule of the court. Therefore, my lords, even after limitation, they say limitation of 30 days, even after limitation it is passed, then it is an incorrect award. It can be challenged under 34, but not in execution. Then, my lords, 1963 SCC online, Supreme Court, page 200. This is a 4-judge bench decision, and it is good till date. It has been followed subsequently by the Supreme Court in many cases. Again, my lords, here the contention was that the suit itself was barred by limitation, and therefore the court had no jurisdiction to entertain the suit, and therefore the decree passed was a nullity. And again, please see what it was held. That even that makes it a bad, but paragraph 8, it makes it illegal but not nullity. Paragraph 8, the first point raised by Pikedi for the appellant is that the decree in OS number 59 of 1093 obtained by Anatha Iyer and his brother in the suit of the hypothecation bond executed by Ityarya in favor of Ramalingan Iyer was a nullity because the suit was barred by time. In assuming that the suit was barred by time, it is difficult to appreciate the contention of the learned counsel that the decree can be treated as a nullity and ignored in subsequent litigation. If the suit was barred by time and yet the court decreed it, the court would be committing an illegality, and therefore the aggrieved party would be entitled to have the decree set aside by preferring an appeal against it. But it is well settled that a court having jurisdiction over the subject matter of the suit and over the parties thereto, though bound to decide right, may decide wrong, and that even though it is decided wrong, It would not be doing something which it had no jurisdiction to do. It had the jurisdiction over the subject matter and it had the jurisdiction over the party, and therefore merely because it made an error in deciding a vital issue in the suit, it cannot be said that it has acted beyond its jurisdiction. And as often been said, courts have jurisdiction to decide right or decide wrong, and even though they decide wrong, the decree rendered by them cannot be treated as nullity. Then, my lords, 2017 8 SCC 116.
Yes.
Lord, here the facts were that arbitration award was passed, against which section 34 application was rejected, award became final. In execution, objections were raised by the judgment debtor that it is a nullity. The executing court rejected, High Court dismissed the revision application, and the Supreme Court in paragraph 27.3 may be seen. All the objections referred above have been raised by the respondent before the arbitrator and or the district judge under 34 of the Act, but certainly none of them could be allowed to be raised in execution. Once the award becomes final and has attained finality as a decree of the civil court, in other words, having regard to the nature of the objection, it is clear that such objections were not capable of being tried in execution proceeding. It is for the reason that they were on facts and pertain to the merit of the controversy which to be decided by the arbitrator, resulting in passing of the order. None of the objections were in relation to the jurisdiction of the court, affecting the root of the very passing of the decree. If the executing court had proved this objection, then it would have travelled behind the decree, which was not permissible in law. An inquiry into fact which ought to have been done in a suit or in an appeal arising out of the suit or proceeding under section 34 of the Act cannot be held in execution proceedings in relation to such award or decree. There was one judgment which points out the distinction between a null and a void decree and an illegal or a wrong decree. That, my lords, એ લોકોના જે જજમેન્ટ સંબંધ છે ને કયો પેરેગ્રાફ છે તે માર્ક કરેલો છે. Hmm? 6 to 10. Sure. But I am relying upon 2004 1 SCC 287. The paragraph 6. What is void has to be clearly understood. A decree can be said to be without jurisdiction and hence a nullity if the court passing the decree has usurped a jurisdiction which it did not have. A mere wrong exercise of jurisdiction does not result in a nullity. The lack of jurisdiction in the court passing the decree must be patent on its face in order to enable the executing court to take cognizance of such a nullity based on want of jurisdiction. Else the normal rule that an executing court cannot go behind the decree must prevail. two things must be clearly borne in mind. Firstly, the court will invalidate an order only if the right remedy is sought by the right person in the right proceedings and circumstances. The order may be a nullity and void, but these terms have no absolute sense. Their meaning is relative depending upon the court's willingness to grant relief in any particular situation. If this principle of illegal relativity is borne in mind, the law can be made to operate justly and reasonably in cases where the doctrine of ultra vires rigidly applied would produce unacceptable results. Secondly, there is a distinction between mere administrative order and decree of court, especially a superior court. The order of a superior court, such as the High Court, must always be obeyed no matter what the flaw it may be thought to contain. Thus, a party who disobeys a High Court order injunction is punishable for contempt, even though it was granted in proceeding deemed to have been irrevocably abandoned owing to the expiry of time limit. A distinction exists between a decree passed by a court having no jurisdiction and consequently being a nullity and not executable, and a decree of the court which is merely illegal or not passed in accordance with the procedure laid down by law. A decree suffering from illegality or irregularity of procedure cannot be termed to be inexecutable by the executing court. The remedy of a person aggrieved by such a decree is to have it set aside in a duly constituted legal proceeding or by a superior court, failing which he must obey the command of the decree. A decree passed by a court of competent jurisdiction cannot be denuded of its efficacy by collateral attack or in incidental proceedings. Finally, I said that there are these different high courts which have taken a view that 47 remedy under the 47 is not available when it comes to execution of a award, on the ground that section 5 bars challenge except in accordance with part 1 of the Arbitration Act. Therefore, arbitration award can be challenged only under 34. Section 5 bars any other challenge, and 47 talks about decree and arbitration.
You already canvassed that point before you commence.
Yes, but there are judgments of those high courts, different high court. We
submit that.
Yes, I'll give a list and I'll submit all those judgments. Okay. I may not cite it right now.
Fair enough.
There are 6 high courts which have taken the view.
Fair
which enough. And now I'll just 10 minutes to deal with the judgment cited by the other side. Now, the first judgment that my learned friend cited was Electrosteel. And a heavy reliance was placed on that. My lord, here the decree was held to be, or rather what had happened was the company had gone into insolvency and bankruptcy proceedings, and the proceedings were initiated before the enclave. There was a moratorium against the company. Before that, the MSMED council was approached by a supplier saying that he had supplied goods to the company and he had a claim against, a recovery claim against that. Once it went before the NCLT, a moratorium was imposed, therefore the proceedings were stopped. Thereafter, resolution plan was accepted. In the resolution plan, all operational creditor, the debt of all operational creditor was extinguished or was considered as nil, and only the financial creditor were awarded some amount. After this resolution plan was accepted, the MSMED council passed the award and adjudicated the claim of the supplier. In that circumstances, the Supreme Court says that now once the resolution plan was accepted under the IBC code, a special statute, then no claim survived. Since there was no claim, the MSMED council under section 18 of the MSMED Act has jurisdiction to entertain claims under section 17 only. But that claim was already written off under the IBC code. So since there was no claim, therefore the MSMED council did not have subject matter jurisdiction. Because by the IBC Act, there was no claim left. Please see paragraph 52. In that view of the matter, we have no hesitation to hold that upon approval of the resolution plan by the NCLT, the claim of the respondent being outside the purview of the resolution plan stood extinguished. The claim itself stood extinguished. Consequently, the order dated so-and-so passed by the presiding officer, commercial court is, therefore the award dated so-and-so is incapable of being executed. Because the claim itself, there was no claim left after the IBC proceeding. Therefore, there was no subject matter jurisdiction. That is how this discussion has taken place. My learned friend only read paragraphs 47 and 48, but did not show the context in which this observation was made. Then, my lord, the second judgment which was relied upon was a division bench judgment of the Gujarat High Court passed in intergo, and then thereafter a Delhi High Court judgment and other judgments. In all those judgments, the case was of unilateral appointment of arbitrator. And as your lordships are aware, now unilateral appointment of arbitrator, the Supreme Court has said that it is invalid. So the logic was that since the appointment itself is a nullity, therefore that arbitrator who was appointed by a wrong procedure, he does not get any subject matter jurisdiction. Therefore, there is inherent lack of jurisdiction, and therefore nullity. That is the line of thought. So this judgment is on that basis. It was unilateral appointment. Same was the other judgment of the Delhi High Court as well. Two other judgments of Delhi High Court were cited, other high courts were cited. Both were inherent lack of jurisdiction. Then, my lords, my learned friend relied upon 2017 SCC Online Bombay 3953, Karupia Mahalingam. It was, lordships, recollect, lordships had observed that this was under section 33, subsection 3, suo motu power. The arbitrator had corrected the award in exercise of powers under 33, subsection 3. But here the issue was, what would be the starting point for those observations my learned friend read, but the context was not told to your lordship. Those observations have to be read in the context that the issue before the court was what would be the starting point for considering limitation for a 34 application, the original award or the modified award. When would the limitation start? And in that context, all these observations were made. So it was proceedings under 34 and in the context of when the limitation would start. All other judgments are, which are relied upon are also in section 34 proceedings, not in execution. All those observations that this timeline award is not made, rectification award is not made within the period of 30 days, therefore it is bad. That finding is in 34 proceedings, not in execution proceeding. As I said, this can be challenged in 34. There, this can be considered, but not in execution proceedings. So, Geojit was one such case. Geojit, my learned friend, Supreme Court judgment, my learned friend relied upon, but it does not say that after, Geojit nowhere says that after 30 days, there is no jurisdiction and there is apparent lack of jurisdiction. And in Geojit, paragraph 16, last 3 lines, section 33, if your lordships have paragraph 16, last 4 lines, page 72 of their compilation, section 33, subsection 6 of 1996, it gives power to the arbitrate tribunal to extend, if necessary, the period of time within which it shall make correction, give interpretation, or make an additional award. So Supreme Court itself says that power is there with the arbitrator to extend the time. So, my lords, all other judgments are in 34 proceedings, not in execution. So, observations have to be considered in that context. हाँ, ऐसा आपको बताइए कि नहीं? I'm obliged for the patient.
Yes, Suraj. Yes.
If my laws will be kind enough to give a mic to the learned counsel so we can also hear it on VC.
Please utilize the microphone. The council is not being able to hear.
Yes, Suraj, we couldn't make out his saying anything.
Please make sure that no overlapping gets. If
No,
he
no,
has covered
I
everything,
will not. So therefore, I have initially told that all point is covered by my friends. I will only elaborate some point on the basis of authority, which is not cited by my language. I am not going on facts.
Factual aspect.
Yes, no, not necessarily, my lord, because factual I accept is argued by my friends. So this is my written argument I have based on some authority. And
You point out the paragraphs that court needs
that
to...
is all. That is the page number 27 of my complaint.
Yes.
But this is the, my lord, the 7 judges authority, full-fledged authority of the Supreme Court, stating, my lord, what is mean by jurisdiction. That is the paragraph 15 on page number page number 36.
Yes.
Underline line, I will start from underline line. Paragraph 15, underline. Jurisdiction means the authority to decide whether judicial or constitutional tribunal is empowered to require an inquiry into the question of law or fact for the purpose of giving decision on its finding thereon cannot be impeached collaterally on the application for the but the binding until used in appeal. So I want to show, my lord, the section 33 gives the power to court after 30 days also. So court can decide it rightly or wrongly. So court jurisdiction not gone. Court doesn't become without jurisdiction. Therefore, my lord, judgment which is passed by the court after 30 days, because it is not become nullity.
Please.
So, my lord, and on second judgment, my lord, my London bench also had taken this judgment and given the page number 86.
Yes.
This, my lord, the paragraph 45, 1, 2, 3, 4 was read by my learned pen, and on the basis of this, my lord, it is very clear that the arbitrator has the jurisdiction after 30 days, 30 days also. So, arbitrator can decide rightly or wrongly, but it doesn't become lack of jurisdiction. That is, my lord, the conclusion which is now, my lord, the lordship is page number 100. What is the principle of natural justice? My lord, it is case that there is no application, no hearing, no notice. What is the consequence of that part of the argument? The award became illegal. It not became void. What is the page 100, page note B. Natural justice agreement need not be specifically mentioned the condition requiring the arbitrator to hear the both parties before deciding the question before him. condition regarding giving opportunity of hearing or allowing the parties to adduce the evidence are implicit in the agreement. Non-compliance, that is important now. Non-compliance with the principle of the natural justice would render the award invalid. So, Maharaj, invalid award cannot be challenged in education. For that, Maharaj, remedy is provided under section 34. They have to go. So, my submission that all points which is raised in execution petition, challenging the execution, is covered under the 34. So, Maharaj, the next point, Maharaj, on page number 101, head note D. Jurisdiction of arbitrator. Respondent continuously submitting the jurisdiction and authority of the arbitrator and taking part in the proceeding without questioning the same. Here, he must be regarding having accepted the same. Objection to in this regard taken only as a stage of proceeding for jurisdiction award under section 47, not tenable. So, my learned friend has specifically detailed arguments on the later dated 15/2/73 and 4/5 of 2003. All this correspondence shows that the National Highway Authority has approached the arbitrator, taken part in the proceeding, taken the change of valuation, and therefore once they have accepted the award, once they have taken the part in the award, they can't challenge the award as a valid, invalid. So, the proceeding taken by them, they have acquiesced the proceeding, and therefore now they have no right to challenge that order. That is the and the page number 110. It's same principle on the executive court can't go behind the decree. When decree and when decree regarding the payment of interest did not award the interest, observing that the executive court cannot set up the grant decree on for interest. Where the court has given the instance, the original decree has not granted interest, but executive court has granted. Therefore, Supreme Court says that executive court has no jurisdiction to go behind the decree. And second part, I want to argue, that the original judgment, which is cited in this judgment of Bombay High Court, that is the old judgment. It is Supreme Court of (1996) 7 Supreme Court 657. It is first judgment where the court says that executive court can't go behind the decree, and there also there was judgment, and in this matter they have given the citation about the earlier judgment. The next judgment, how executive court can entertain the plea of nullity without jurisdictions and all these things. The court, it is last judgment, since she is a page number 128.
Yes.
The court says that when the objection of the jurisdiction or court to pass decree does not appear on face of record and require examination of the question raised and decide at the trial, or which could have been but have not been raised. The point which is not raised initially, because they have appeared before the arbitrator, taken part, demanded review. On that point, they have to raise the objection. So we have no jurisdiction. We have goes beyond 30 days. They have not done that. Now, this point, whether they have raised the point of whether they have not raised the point initially, then they can't raise that point in education. which point which is requires examination. So about 30 days. It is our case that we appear within 15 days. We are given time of 28 and thereafter we have filed a return. They have denied us. The question requires a examination, whether we appear within 30 days or not. So executive court has not that jurisdiction. It must be appear face on record without any inquiry. If it is appear face of record, then it can say that it is negligent. So all this judgment, and on the basis of judgment, I set up my argument, written argument, and this is the only argument. All this point is covered.
Yes, counsel.
Yes, Manoj. So, Manoj, let me see. So, Manoj, there are, to my understanding, I wish to make 3-4 points. And regarding one of the issues, I'll have to file an affidavit or submissions to this Honorable Court. But let me finish the rebuttal. What has been remanded back to this Honorable Court has been to really decide the question of Section 33. I'm repeating this again, Para 8 and 10 of the High Court judgment, because majority of the controversy was relating to Section 33. Now, Manoj, the position, I repeat only at this point, Section 33, under 33, 1, 2, 3, 4, each of the sections is required to be in 30 days, whether suo motu or by application, whichever way it goes, 30 days and with notice. Now, Manoj, even though my learned friends have tried to, beat the bush around and talk about some oral hearing for the first time before this Honorable Court, it was not raised at any time. There is nothing to support that, Manoj, from the application which is on record, which is not disputed by them, nor by the Margdarshan Award, which has any bearing. So, Manoj, the two things that emerge from page 371 are the fact that the application was moved on 16/9. The second thing that emerges from there is that there is no notice to anybody, not to me. If they've done anything behind my back, Manoj, it's not relevant to me. So, Manoj, if I come back to the proposition in hand with Geojit, which has been ultimately, Manoj, followed in 2-3 of the judgments, in clear terms, the mandate is this: 30 days, extendable by consent. In the first instance, I had said, so I'm not saying it is not extendable by consent. But there is no question of consent in this case. It has all been done behind my back. Consent is a very far cry. So, Manoj, 30 days is mandatory and notice is mandatory. In the absence of this, Manoj, the proceedings need to be quashed. It's as simple as that. So, Manoj, I don't wish to keep re-agitating the same issues. Those judgments are there. We'll give a short written submission on that part just to support. But Electroseal, Integro, and then, Manoj, in fact, Karupriya, in terms of Lords, again deals with the same issues. I'm just repeating the names. I've given those judgments, I will give it again. We can't go back and forth, Lords, on this. So, if, Lords, 33 itself is bad, Lords, illegal, outside time, contrary to the law laid down by the Supreme Court, because all those earlier judgments my learned friends have cited of High Courts, Lords, Electrosteel is of 2025. Integro, Lords, of this Honorable Court, Lords, is also of 2024. All those judgments are prior to no avail. Because I'll tell you, Lordships, a very fair question. In my career also, my Lords, at one point of time we used to say, in execution you can't raise anything beyond the decree. If you want to challenge the decree in CPC, go to CPC. But because the law has evolved itself, I can't go back on that. And I'm sure your Lordship is of a younger genre, my Lords. So your Lordship has probably only seen this time. So today, my Lords, the Supreme Court has said you have to do it. The High Court says you have to do it. Because I'm afraid we'll have to do it. We have no choice but to stay under the mandate of law only, my Lords. So therefore, these objections, my Lords, Section 33 is out of time. The entire proceedings regarding the Margdarshan and all are beyond time. My learned friends, Lords, averments relating to these so-called oral hearing, as I mentioned, is for the first time before this Honorable Court. Your Lordship can take it prior to this last rejoinder. They have never raised this issue of any oral statement. And even if there is any oral meeting, my Lords, any meeting of theirs is not a Section 33 proceeding, with due respect. And finally, my Lords, the law lays down that the burden, once I have put, my Lords, and the law has put a burden on them to show when they did Section 33, I don't have to show it. They have to show when they did Section 33. मैंने आज कह दिया कि मेरी meeting हुई है is not good enough for any purposes, but just for reference for law on this part, my Lords. Once I state, my lords, they filed it outside time, I put the application on record through an RTI, and the Margdarshan award itself shows whatever it does, my lords. Then the burden falls on them, and burden falls in a full way, not by saying I said X date, therefore X date applies. Now, my lords, if your lordship will just see two judgments on this burden of proof, my lords. These I have not cited earlier. This is D.D. Kumaraswamy, my lords. This is in volume 2. And this is, my lords, page 5. Also under the Arbitration Act. My lords, kindly just note it, my lords, your lordship did not go through it, my lords. This is a High Court judgment, which says the court has to satisfy itself in terms. And then, my lords, the second judgment is Mani Nariman, which is in same volume, page 13, para 12 and 13. And here, my lords, I'll just read out the relevant part. Your lordship will take out volume 2, para 12. It's a Maharashtra judgment. Page 13 at the bottom. 1-3. Page 1-3, 13, para 12. 5 lines from the bottom.
No.
Volume 2.
Volume 2, probably this one is a third one.
There are 3 volumes.
Anyway, I find out. Chal. Yes.
May I read it out? It follows that an obstructionist can always contend that the decree under execution is a nullity, and therefore the courts are refrained from entertaining an application for...
Hey, just a minute. Which para you are referring?
Para 12.
Just. In my view.
Yes. Yes, my lords. In that line 5 from the bottom.
Okay.
It follows
Yes, it
that,
follows an obstruction.
that an obstructionist can always contend that the decree under execution is a nullity, and therefore the courts are refrained from entertaining an application for removal of the obstruction. Once such a contention is raised, it will be for the decree holder to establish that the decree which he has put in execution is a valid decree, and the same is being capable of being executed. In my view, the above contention can be raised by an obstructionist even if he fails to establish that he has got an independent right of possession. The holding of a valid decree is a sine qua non for initiation of proceedings under Rules 97 to 101 of Order 21 of CPC. If the decree under execution is a nullity, the decree holder will not be heard to say that the obstructionist is illegally resisting its execution. Then if your lordship will see para 13 at the bottom, my lords, of para 13, next page.
Yes.
At last 5 lines of para 13, if this be so.
Yes.
If this be so, the decree holder has to first establish that the decree which he has put in execution is a valid decree for possession. Consequently, it follows that it will be open to the obstructionist to raise a contention that the said decree being a nullity is not liable to be executed, and this is despite the fact that he cannot establish his independent right to possession. So what this is basically saying is, once I have taken an objection, let the decree holder prove his own case. He has to prove it. So simply by averments, in any case it will not be so. I have put on record documents. He is to show a rebuttal to that. Otherwise, my lords, on the face of it, the application is outside time. It's not even an application. I was told by my colleagues to argue that it's just a letter, which is whatever it is. They are contending is 33. On their contention, it is 33. They moved it on 16-9. That is what the record shows. And therefore, my lords, even an earlier meeting that they had, and nothing shows notice to me. Nothing. Nothing. So, my lords, Geojit, as I said, had been confirmed in any case in as many words, my lords, and it is again confirmed. I'll point out one more judgment, my lords, in that respect, in as many words. Now, my lords, my learned friend again have argued, my lords, on 2-3 things which I will just show, my lords. So, one part, my lords, they argued is at length that NHI has participated in several proceedings where they have invoked after 30 days and they have accepted the procedure, and therefore NHI is bound, and therefore, my lords, this should happen. Because firstly, my lords, any kind of participation is not estoppel in law. I in law cannot confer jurisdiction. Even there are judgments to that effect. I will just show that in a moment. Second proposition, my lords. In some other proceedings, what happened is not relevant to this honorable court. I can still understand for a moment, without prejudice, that I participated in these proceedings and some contention is made. But my lord, that is not the case. They are saying in other awards, similar village, something happened. I went after 33 period, 30 days of time, I participated, therefore I am bound, my lords. Therefore, I have impliedly accepted this procedure. Well, I don't know where they can get all this from. Be that as it may, my lords, whatever judgment prevailed, I am not here to answer the other cases. They are not before your lordship. They are of no avail whatsoever. In the present proceedings, my lords, there is nothing to show, my lords, any kind of acceptance of this procedure. It has all been done behind my back. It is contrary to law, and I stand on that, my lords. But the judgments, my lords, in any case, 2-3 judgments to this effect, my lords. If your lordship will take, my lords, volume 1,
Yes.
the law says even if I participate, I can take a plea. And this is, my lords, at page 164 of volume 1. This is a judgment of the Supreme Court of 2017, Bharat Udyog. Yes, my lords. Just a short paragraph, paragraph E,
Yes.
at page 164.
Yes.
There is the participation does not confer jurisdiction. There is no estoppel against a municipal council for the reason that it had initially participated in the arbitral proceedings. This is for the reason that they were forced into arbitration without consent and contract. At the same time, they challenged the award on jurisdictional grounds before the civil court as well as the high court. And then, my lords, ultimately the same are set aside by saying that participation doesn't amount to consent, nor is there estoppel. Now, my lords, again, there the judgment of DG, my lords, which is at page this is a Delhi High Court judgment, my lords. I've read it earlier, but I need to read it to your lordship, my lords. It actually brings out quite a few things. This is in volume 3. I'm sorry to inconvenience your lordship to go up and down the various volumes. This is a 2026 judgment. And this is under section 33. This also confirms Geojit says it's mandatory. Para 3 at page 47. In furtherance of said objection, learned counsel for the respondent submits that the application under section 33 preferred by the petitioner seeking correction of the original award before the learned arbitral tribunal was itself filed beyond the statutory period of 30 days prescribed under section 33 of the Act. The learned counsel contends that once such an application came to be filed beyond the prescribed period, the learned arbitral tribunal had already become functionis officio, and consequently the corrected award would be rendered non-est in the eyes of law. Support of his contention placed reliance on Supreme Court in Geojit Financial Services versus Sandeep Gaurav, which summarizes all this is a conclusion of Geojit. I had read out paragraph 4 at page 48, my lords, to your lordship. In paragraph 6, my lords, the learned counsel for the respondent accordingly submits that once a corrected award is rendered legally unsustainable and honest in the eyes of law, the limitation for filing the present petition would necessarily have to be reckoned from the date of receipt of the original award. The learned counsel for the respondent in this regard contends that the original award came to be received by the Director General of Married Accommodation Project on so-and-so, and therefore the petition, having been filed on so-and-so, which is beyond the prescribed period of 3 months and further condonable period of 30 days under section 34. That is section 34, my lords. There you have a further period, is liable to be dismissed as barred by limitation. And then, my lords, after having considered Geojit and all, kindly turn to page 55. Para 35. At this stage, has your lordship got that?
Yes.
The alternate yes, that is before, just that is the conclusion, this is the last part. At this stage, the alternate contention of the petitioner that there existed a deemed waiver to object. My learned friends are saying I did not come at the first opportunity, I came late. Section 4 amounted to a waiver because of the Arbitration Act. Now, this deals with that issue in terms. Whereas I came on the first instance when the execution was filed. I don't know anything before that. I don't know such an award has been passed. I have given no notice. That is my case. So, Milos, where do I know? In any case, this is my first feeling. And Milos, here's the law. At this stage, the alternate contention of the petitioner that existed a deemed waiver to object in terms of Section 4 of the limitation period of 30 days as under Section 33 of the Act, and consequently the expression in Section 33, unless another period of time has been agreed upon by the parties, assumes importance and requires careful adjudication. Para 37, Milos, a plain reading of Section 4 of the Act demonstrates that the provision operates within a limited and specific sphere. It applies to situations where a party, despite having knowledge of either a derogable provision of the Act or any non-compliance with the requirement under the arbitration agreement, nevertheless proceeds with the arbitral proceedings without raising a timely objection thereto. In such circumstances, the consequence contemplated under Section 4 is merely a deemed waiver of the right to subsequently object to such non-compliance. Section 4 of the Act is reproduced hereunder for ready reference. I'll pause for a minute. In addition to all this, my lords, the fact that Section 4 doesn't apply, I knew nothing about the award. That is my case. It was filed and done behind my back, which is a matter of record. The Honorable High Court has directed that this must be considered for Section 33 import. So, my lords, it no longer remains even open for all this to be pleaded before this Honorable Court. The High Court has said it must be considered. So, it is not that, my lords, there is any such deemed waiver provision which will even apply otherwise. And then, my lords, para 38. In the present case, once the application under Section 33 of the Act was filed beyond the prescribed statutory period of 30 days, the learned arbitral tribunal had already become functions officio in respect of the award in question. Consequently, the jurisdiction of the learned arbitral tribunal to entertain such application stood extinguished in operation of law itself. Section 4 clearly contemplates a waiver would operate during the pendency of the arbitration and not post the conclusion. In this case, it's post the conclusion. The Markdarshan award has happened, execution is there. This is apparent by the use of the word and yet proceeds with the arbitration. So Section 4 doesn't apply on two counts. One, this action is post-arbitration. Section 4 only applies through arbitration. And secondly, my lords, we have come on the first opportunity, so there is no such question of late coming, even though that is not for them to say. I came to know, I filed at the execution, I filed my objections. Then was para 44. I'm sorry, para 40. In such circumstances, mere absence of objection on the part of the respondent before the learned arbitral tribunal cannot be construed as resuscitating or bringing back to life a concluded proceedings without strictly following the statutory mandate of Section 33 of the Act. This would amount to conferring jurisdiction upon the learned arbitral tribunal contrary to the statutory scheme of the Act. Jurisdiction that stands exhausted by operation of law cannot be revived by acquiescence, silence, or implied waiver. A bare perusal of Section 33 makes it evident that the only manner in which the period prescribed under Section 33 of the Act could have been extended was through an agreement between the parties, stipulating another period of time. This provision itself expressly contemplates that an application seeking correction or interpretation of an award is to be filed within 30 days from the date of receipt of the award, unless another period of time has been agreed upon by the parties. Not in the present case, there was no such agreement nor alleged. Para 44. In this view of the matter, this court of the opinion that absent a prior agreement as between the parties, as between the parties with respect to the time for filing of the Section 33, the filing of the same before a tribunal which after rendering the award had become functions officio would be rendered non-est. Further, the Supreme Court in Georgiev has itself recognized that an application under Section 33 of the Act filed beyond the prescribed statutory period would not extend, well, that is relating to Section 34. I will not bother your lordships. And then was para 49 on the next page. In view of the foregoing discussion, this court has considered opinion that the application under Section 33 of the Act was barred by limitation. Consequently, the learned arbitral tribunal has become functions officio in relation to the award in question and therefore lacked jurisdiction to entertain or allow the application. Corrected award having been rendered pursuant to a time-barred application under Section 33 is accordingly rendered legally unsustainable and non-est in the eyes of the law. And therefore, my lords, para 56. The present petition is clearly barred by limitation, is liable to be dismissed on this ground alone. Now, my lords, after this, there is one other point they raise, my lords, relating to NDMC judgment, my lords. My lords, before I even read it, my lords, the clear issue is, my lords, that NDMC was a case whereby consent of parties, my lords, and by the court, the time was extended. Now, my lords, NDMC, my lords, is... Would somebody give where the copy is? I don't know. Samrat?
Ma'am, they have supplied the court with the copy.
Yes, Milos, your lordships, they have supplied the court with the copy. Milos, I'll just refer to that.
New Delhi Municipal Corporation versus SA Builders.
Yes.
Milos, this they have relied upon the fact of how the court has, Milos, intervened and there is extension of time of 30 beyond 30 days, and therefore that is possible. Now, my lords, very clearly in this case, I'll just read out some of the paragraphs. There was an agreement between the parties relating to extension of time, and the court, my lords, said so. Therefore, my lords, in particular, I will show to your lordship, my lords. Kindly see paragraph 67 at page 166.
Ma'am, the initial para, the 50s paras.
Yeah, I'll come to that later. Just 1 minute.
Yes.
So, my lords, para 67 at page 166.
Yes.
Thus, as can be seen, the impugned order is a consent order. The division bench of the High Court, after taking the consent of the parties, had remitted back to the High Court only to make calculations, etc., before the learned single judge on the quantum payable. If that be the position, it is not open to the appellant to assail the aforesaid order. And therefore, my lords, kindly see paragraph 69 at the end, my lords. In view of what we have discussed above, the interpretation given by us to section 33 and on a cumulative assessment of the attendant facts and circumstances, we are of the view that the clarification sought for and issued by the learned arbitrator would be covered by the expression unless another period of time has been agreed upon by the parties appearing in section 33. This is a case where the court had permitted the respondent, to seek clarification of the learned arbitrator beyond the initial period of 30 days, whereafter the appellant fully participated in the clarificatory proceeding. I neither participated in the clarificatory proceeding, nor has the court granted any additional time, my lords. So NDMC is only that in the given case, my lords, High Court directed beyond the 30 days very well. It was accepted by the parties, they went on and they participated. This is so unfair a proposition of law that my learned friend has tried to, was to say this judgment in any way binds. Yes, my lords, law says, I read it in the first instance, 33 gives option to the parties to extend the time, but only by agreement of parties can it be extended. In our case, my lords, forget extension, my lords, is beyond my knowledge. There is no question, and it is beyond notice. So, it could have been extended, not to say, but it has not been extended by anybody's averment. It is not their case, it has been extended, my lords. Then today they can't turn around, my lords, and try and take advantage of another case where extension was granted by the court and permitted the arbitrator, my lords, and they participated. After that, they consented. I was neither party, nor I consented, nor I was asked, nor do I know. So, because on square terms, my lords, it doesn't. And then if your lordship will just take, my lords, DG married accommodation, my lords. That is a judgment, my lords, which I have filed at page 57 of volume 3.
Which one?
Because this is called DG married accommodation, volume 3, page 56. I read it out earlier to your lordship, some part. This deals with NDMC also in terms.
Yes.
Plus para 44 at page 56. In this view of the matter, the court is of the opinion that absent a prior agreement as between the parties with respect to the time for filing of 33 application, the filing of the same before a tribunal which after rendering the award had become functionis officio would be rendered non-est. Further, the Supreme Court in Geojit Financial Services has itself recognized that an application under section 33 of the Act filed beyond the prescribed statutory period would not extend the period of limitation under section 34 of the Act, which in the considered opinion of this court is what is being sought by the petitioner. Upon the expiry of the statutory period, the learned tribunal becomes functionis officio, and any correction carried out thereafter, if not carried out strictly in terms of 33, would be rendered legally sustainable. This court is also of the considered opinion that the reliance placed by the petitioner on the judgment of Supreme Court in NDMC is misconceived and in fact operates contrary to the case sought to be canvassed by the petitioner. A perusal of paragraphs 53 and 54 of the judgment which have been relied upon by the petitioner would reveal that the Supreme Court itself has recognized that although period of limitation is of 30 days is not inflexible, any extension thereto can arise only where another period of time has been agreed upon by the parties. The said judgment therefore reinforces the requirement of a bilateral agreement explicitly indicating consensus ad idem between the parties for extension of the prescribed timeline and does not support the contention that such extension can be inferred by implication, acquiescence, silence, or absence of objection under section 4. So all their arguments are clearly met in this judgment in as many words. In the present case, no material whatsoever has been placed on record to demonstrate the existence of any express agreement or any act indicating a prior consensus addendum between the parties extending the statutory period prescribed under section 33 of the Act. Consequently, the reliance upon NDMC builders does not advance the case of the petitioner. In view of the foregoing discussion, the court is of the considered opinion the application under 33 is barred by limitation. The tribunal has become functionis officio in relation to the award in question and therefore lack jurisdiction to entertain or allow the said application. The corrected award having been rendered pursuant to a time-barred application under section 33 is accordingly rendered legally unsustainable and non-est in the eyes of law. And that, my lords, more or less summarizes my arguments, my lords, aside from what I submitted earlier, to which I will give a written note to help your lordships, my lords, which hopefully will not be too long because we've already taken a lot of time. I do need to, my lords, some little time to file, my lords, an affidavit in relation to the other issue, which is in a sense unrelated to section 33 totally, but because the amounts paid under the 6622 award, the earlier award, since your lordship had brought it up, I had wanted to delink it, but your lordship heard it so very well, my lords. But I need to file an affidavit, my lords, relating to the amounts paid in satisfaction, because what has happened, my lords, is this. In essence, the first award, my lords, put down whatever it did. I don't have all the details.
In advance so that they can make out whatever they did.
Yes, we'll do that. So, my lords, I'll do that. But to say this, my lords, that the structure, trees, etc.
According to opportunity to run.
Very well, very well.
God, if we go stricto sensu, we will not reach out to culmination. See, I am not going to give any further hearing to effect. Whatever you want to give it, you give it in writing.
Yes, my lords, very well. I am happy with that, my lords.
I understand the council.
You file your additional pleadings, then opportunity is given to me to file reply.
Council, have I not accorded opportunities to parties by giving by making leverage to all the parties? Have I not accorded the opportunity to expand the scope to the extent stricto sensu? If we are etymologically to interpret every segment and microscopically make out, we will not reach out to conclusion to it. Let it be. I say I have given very patient hearing. Now no further oral submissions are to make out. Whatever you want to make out, you want to. When you confine only to those the averments that the other side has actually made out during the oral submission.
Yes.
That reference would be there. So,
yes, sir.
Sure. When you will complete all these things?
My lords, it should take us at least 3 weeks, my lords.
3 weeks?
I'm sorry, because I'm bothering your lordship, but slight constraint, my lords.
Then let us make out that you find the oral submission, we will look at it. Sure.
No, my lords, make it 2 weeks, my lords. I need to have some time.
1 week. 1 week is.
1 week won't do, my lords. 1 week won't be possible. I need 2 weeks minimum.
10 days, chalo.
मेरा 2 वीक कर दीजिए, मैं तो 3 वीक से 2 वीक बोल दिया. नहीं होगा, नहीं होगा.
10 days हो जाए.
मतलब 2 वीक कर दे. It's only 4 more days.
चलो 10th June.
मतलब 10th June तो कहाँ होगा अभी? We are on 1st June. Kindly make it 15th June, my lords. Thank you.
પણ આના પછી કોઈ હિયરિંગ નહીં થાય.
हाँ ठीक है, my lords.
15th June I am making only a formal date. તમારે બી જે જજમેન્ટ આપવા છે તમે હા બસ ચાલ.
It would be subject to our contention that High Court had said that they have to file their objection, I have to file my reply, they have to file rejoinder.
This will be oral submission only.
After the pleadings are over, then the hearing.
This will not be a pleading.
Yes, so they are saying they want to file an affidavit.
This is not a pleading. It's a kind of a
note. Not an affidavit.
Not a kind. Even if be on affidavit, you can respond. It's a kind, not a kind of pleading. Pleading counsel is a suffering. It's a different aspect of it.
સાહેબ આજે પહેલા સૌથી પહેલું એમને
પૂરું
Grateful, my lords.
કરવું તો પછી હવે આ બધામાં તમે યાર આટલું બધું in a lighter sense, once the court has reached out to retire.
My lords, your voice has gone off. Yes, sir.
My lords, you're on mute.
Yes, my lords.
That says that this be a last date. It has to be.
Grateful, my lords.
Grateful. Enjoy.
grateful to the court for the patient hearing.
I'm thankful, Doctor.